My lord, that Rama Prasad Sarkar matter, my lord, where my lord 5 has increased to 6. Now, my lord, what has happened? My lord, I'm getting notices, my lord, to allow my lord others, my lord, to come in. I have no objection. My lord, in fact, I have now asked 7 because one notice was forwarded to me. I had, my lord, forwarded it to the department saying, call whoever wants to come. So, my lord, that might keep happening. Kindly give us liberty, my lord, to entertain as many, my lord, so that we can have a...
We don't, that will be better.
My lord,
Will be better.
no, if they already represented the particular union, well and good. If the other union...
No, we will not make that as an order.
No, my lord, I'm just informing your lordship that I'll be doing this.
That discretion is with the state.
Yes, my lord, kindly, my lord, don't let it, my lord, later argued that I overstepped your lordship.
No.
Because they are all coming in. In fact, when he mentioned yesterday, I said, if you had given me notice, I would have said that from this union, that's coordination committee, I had received a request for 2. And I had forwarded it, telling the department to call 2, and I would have, my lord, clarified that yesterday. So, my lord,
I have intimated him.
All right, that's my, all right. Thank you.
My lord, may I be permitted to mention one group 4 new appeal for listing in?
New appeal.
Lordship, may I take leave
My
to
lord,
file
kindly-
appeal without certified? Lordship, it is group 4 matter and appeals has been disposed of. We have applied already. It's 11th April.
All right.
My lord, may I
Lord,
permitted to file a memo without certified copy?
What is the
Kindly,
date?
kindly grant me
What is the date of the order?
12th.
already order है ये 2021 साल है और मोटिवेशन
12th April. I have already applied for the
All right. What is the urgency? It's a group 9 matter.
group name matter.
What is the urgency?
My lord, urgency is that the
Because around
Because
200 matters are there, sir. Group 9 matters.
the appellant, my client is suffering very much.
No, what is the issue?
Is facing the
Police inaction.
not police along with police in action along with the violence, family violence.
It's better you file with certified copy. It won't get listed.
My lord,
That's
I
the
have
problem.
already applied for the certified
You
copy.
just see
Kindly-
for a
kindly-
week. If you're not able to get it, then you mention again.
My lord, kindly recall I mentioned this matter on Tuesday, the 18th, my lord. And your lordship directed me to ask my client to write a letter for assignment of the matter to a different single bench. My lord, my client is suffering from cancer patient. He's a cancer patient, my lord. And my lord,
Already we have given. I think yesterday I've already passed an order.
Your Lordship, with your kind permission,
Yes, sir.
I would like to mention 2 matters. These are identical, though not tagged yet together. One has been in the monthly list since September last year, and the other has gone to the monthly list this year. Both these pertain to illegal land acquisition in Birbhum, and there is an urgency in view of the fact that the acquisition is still continuing.
What is the item number in today's month?
One is WPA P 236 of 2022, and the other is WPA P.
No, the item number.
But Your Lordship, these are
The monthly list.
in the monthly list.
What
both
do-
in the monthly list. I'll just give the item numbers and
You give the letter, let us.
I have your
Please,
lordships
wait
kindly
for your
to
lordship.
mention a matter, my lord. This is an appeal extremely urgent. My lord, from an order in contempt by which, my lord, the main order passed in a writ petition, my lord, is sought to be, my lord, enforced while, my lord, the appeal is pending and is being heard. I was a party to the writ petition, not made a party in the contempt. Behind my back, my lord, an order sought to be
Yes,
passed.
yes.
My lord,
Leave granted.
my lord, there are 2 leaves which I require. One is, my lord, leave to file without a certified copy, my lord. And the second, my lord, leave, my lord, to file the appeal because, my lord, it's a third party appeal, my lord, because I'm not a party in the contempt. So
You
both
can-
leaves will be required.
Yes.
You have to take out an application for leave to file an
My
appeal.
lord, I have made that prayer.
yes.
I have made that prayer.
Leave granted.
My lord, one other thing, I'm sorry, my lord, to trouble your lordships, my lord. One other thing, my lord, if it could appear on Monday because it's extremely urgent, my lord, it's ought to be.
Let us
addressed.
see. You please give the
I'm
papers.
very grateful, my lord. Very grateful.
Please call the list.
Appellate side daily list item number 1.
I'm for the petitioner, my lord.
I'm
In
for the
my
respondent
instant
number 9.
matter, the matter has come before your lordship for correction. On 11th April 2003, my lord, Mr. R. Ghurai appearing on behalf of the appellant and submitted before your lordship is one SLP has been filed and SLP was disposed of. A direction was given upon the appellant to file a review application instead of correction of the order. On that day, my lord, I being the respondent number 9 appeared on behalf of the respondent number 9 against my client, the grievance. So my lord, my name was not in the order sheet as well as the appellant advocate's name was not there.
Yes, yes, appellant's advocate's name are there. my
Putra
lord.
Mukhopadhyay and Soma Chakraborty.
Yeah, on that
Soma
day,
Chakraborty not there. Mr.
I
R. Ghodai appear and submitted before your lordship the SLP order.
yes, my lord, Mr.
Yes,
R.
Soma Chakraborty and Subrata Mukhopadhyay was not there, my lord.
My lord, Shoma Chakraborty was the advocate on record. I am.
Maybe that
I
day
am-
he was not there. Mr. R. Ghodai
I
appeared
invite you to
and submitted the before your lordship the
Wait.
SLP order.
Please hear us. Here the procedure is, they give a slip,
Yes.
they give a slip to the AR court.
Yes.
In that they write 4 names. All 4 names will be.
I have given my list.
Your name will be included. That's
Yes.
it. Yes.
And that
In
day,
this
Mr. Ghodai appear on behalf of the appellant.
All right.
That because he has submitted the SLP order.
Please.
Yes, my lord.
I am appealing for the UGC, my lord.
Next.
Item number 2.
What is this to be mentioned?
Came up for hearing last time, your lordship directed to be kept it under to be mentioned. That is why it is there. It is for hearing, in fact, your lordship.
And for the union.
On the last occasion, my lord had directed the petitioner to serve upon me, my lord.
We can't fix a date before vacation.
Yes, your lordship.
You see the board here. The PAL. Even for 10 years, we continue doing it, it can't be dismissed.
My lord, what I request your lordship is that I will keep my submission short. For say, you can fix up a time limit, say 45 minutes to 1 hour. And I will conclude my submission within that time. Because my lord, the issue in this petition is very short. That whether the item which I manufacture can be called a item of textile, even if, my lord, it is manufactured from plastic. My lord, it is manufactured from polypropylene. And chapter 63, which is relating to textile, it says that
This matter relating to advance ruling, my lord. Appellate authority advance ruling.
At least take minimum 2 hours.
Yes, 2 hours at least.
It will take minimum 2 hours for
for
both.
both the sides, that I agree. It will take 2 hours.
All right.
for both the sides.
Since appeal has to be heard finally, for want of time, it cannot be taken up during before summer vacation. Hence, list the matter under the caption for directions on 9th June. Let it come on 9th June. Let me see. Next.
Item number 3.
I appear on behalf of the appellant, lord.
Grateful one.
Item 3.
I beg to appear on behalf of the appellate. My lord, the impugn order under challenge before lordship, my lord, is page 215. Starts from page 214. Before that, my lord, I beg to draw your lordship's attention, my lord. Page 214, kindly come to that page. And I say P19. The petitioner moved. Page 214, my lord, the last paragraph. From record, it appears that the responding authorities who have issued the impugned notices, orders, and have been impleaded in this writ petition do not have their office within the territorial jurisdiction of this court. Only on that finding, my lord, my petition was not taken into consideration.
Very good.
Subsequently, my lord, we moved in another application showing that part of cause of action, entire cause of action mostly, my lord, was within this territorial jurisdiction. Kindly come to, my lord, page 114 for a moment. And it's a P9.
But then you file an appeal against the order dated 1st February.
But my lord, in that case, my lord, as we did not implead.
No,
by
we
mistake-
will adjourn this appeal. You file another appeal against the order in the other writ petition, 1st of February. We'll hear both the appeals. Otherwise, it's
That will take, but I beg to draw lots of attention. My lord, the second application was filed only on that ground that on earlier
no,
occasion.
it can't be. No. See, you can question the correctness of the order in an appeal by saying that, sorry, part of the cause of action arose within this court, jurisdiction of this court, therefore it is maintainable. See, additional grounds, a fresh writ petition won't be maintainable. We will adjourn the matter. You take a decision at the request of the learned advocate.
Our only problem is, my lord, 24th is the date for hearing there. So I
You advise your client.
pray before lordship, my lord, kindly give me leave so that I can.
No leave can be. You please advise your
In the
client.
meantime, my lord, delay has been caused, my lord, so that delay was there, my lord. In that case, delay will be there.
At the request of so and so, adjourn. Next.
Item number 4,
Obviously, lordship.
Why your application was rejected on the ground of locus standi?
Lordship, I received a contract, I was entering into a rental agreement with Kolkata Port Trust for lease of a particular area of the land for a period fixed under the agreement, Lordship. Lordship, as per the statute, the upfront lease premium which I pay to KOPT is an exempted. There is no GST on it, and monthly lease rental are taxable. But KOPT was telling that no, you have to pay us GST on the upfront lease premium also. So we wrote letters to them that it is not payable, but notwithstanding anything, they stated that we will cancel your rental unless you, or they stated you bring an order, it is not applicable. That was the fact. So Lordship, we applied to the AAR, Advanced Ruling Authority, Lordship, under section 98(2) of the CGST Act, which is there at page 147, Lordship, of the stay. All the legal provisions are at page 147, Lordship. Lordship, AAR under section 98(2), Lordship, page 148 is section 98, procedure on receipt of application. Lordship, 98(2), if I may read. The authority may, after examining the application and the records called for, and after hearing the applicant or his authorized representative and the concerned officer or his authorized representative by order, either admit or reject the application. So our application was filed. They called us for hearing. On the day of hearing, they stated, you are not eligible to get a ruling because you are not a service provider. You are asking for a ruling whether this particular activity is taxable under GST or not. But you are not a service provider, so I will not give you a ruling. So the locus standi was, they stated the order of the AAR was only a service provider can seek a ruling, which is not as per the law, Lordship. Kindly come to section 95, Lordship, at page 190, at page 147. Lordship, 95 subsection C. It says applicant means any person registered or desirous of obtaining registration. Then Lordship, 98. So section 97, Lordship, 97(2).
Desirous of obtaining under this chapter,
Lordship, so these are the criteria on which I can seek an advance ruling. And 97(2), Lordship, applicability of a notification issued under the provisions of this Act, 97(2)(b). So my point before the learned AAR was, I am seeking an advance ruling whether the notification 12/2017, which is exempting this particular levy, is applicable in my case or not. To which the AAR stated, you are not a service provider. The law, Lordship, in fact, your Lordship has passed an order in case of Gayatri project, Lordship, wherein in similar state, your Lordships are held that applicant is a very wide term. It is to be whoever is aggrieved. An aggrieved person can go to a AAR. Lordship, para 7. Para 7 of your Lordship's order, it stated that any person who is aggrieved. In this particular case, Lordship, I was not made a party, and by your Lordship's direction, AAR was told that you hear me and then pass an order. So your Lordships deciphered the scope of AAR. And Lordship, the learned single judge stated.
No, this was a case where you wanted to file an appeal against.
Lordship, this was the case where I was not made a party by ECL.
But I'm sorry to interject, my lord. In this case, the honorable single judge, my lord, though he cannot prefer an appeal under section 100 because no order has been passed. But the honorable single judge has granted him liberty to approach the appellate authority. I do not know, my lord.
Lordship, kindly come to.
No, the problem is.
Lordship, kindly come to the order, Lordship.
If the application had been decided on merits, probably we can relegate him to the appellate authority. But the authority says,
On the ground of locus standi, my lord,
but
that my lord, he is a recipient of service, he cannot.
no, under the rules, please point out that applicant means any person
Any person
registered
registered
or
desirous of obtaining
so
registration under the act.
he is a registered
Registered, my lord. So
dealer.
it was not decided.
Lordship, so it has to go back to the double AR to decide on merits.
My lord,
No, that will be better, no? If you come to page 142, that's where the
The discussion and finding of the double AR is there.
application for advance 1.8 can be filed by any person registered or desirous also. And the law nowhere states that the applicant has to be a supplier
Lordship.
in order to, this is a submission. So let us see,
Lordship, para 1.10 is the double AR's find.
in the instant case, applicant being a recipient of services has sought for advance ruling. So and so, so and so, so and so, so and so. Aggregate, etc., etc.
They have taken to a definition of what is turnover. It is not your part of turnover, so we will not give you a ruling, Lordship. It is based on total entirely different facts, Lordship.
my lord, since my lord, this locus standi is coupled with the facts, my lord, because the fact says that he is
Merits
a
have not been decided, Lordship.
my lord,
You
it can be remanded back because that for that precise reason, the honorable single judge, my lord, subject to a lordship's kind sanction, has granted him liberty because as per section 100, he could not have gone before the appellate authority because there is no ruling in his favor.
Lordship, kindly come to single judge, Lordship single judge's order, which is at page 24 of the stay. I have been given liberty and my limitation has been condoned. It is not that had the learned single judge ordered that, okay, triple AR, you here on merits. That is not the case, Lordship. And Lordship, because double AR has not given any finding on merits, it is not possible for the triple AR to give me an order on merits, Lordship.
Had to be condoned because of in view of section 100 subsection 2.
No, the term applicant has been defined. The word applicant has been
95C.
defined in the most widest.
Lordship.
For any person registered or desirous of a person who's not even a registered dealer can approach.
In fact, Lordship, in the GST portal, if I am an unregistered person, I have to take a temporary number just for the purpose of filing an application. I have to pay 10,000 rupees as the fees and I can file any citizen of India.
Nobody is into fact now because only
No, unfortunately, the tribunal did an exercise which is not required at all.
Lordship,
From
my lord,
1.1
what I have found, my lord, even in Gujarat Advance Authority of Advance Ruling, my lord, they have taken the same view that the recipient of service cannot ask for this, my lord, and that is recorded in the order of the Authority for Advance Ruling.
Lordship,
Some other states also, my lord.
Lordship, but each authority is different. Each
because-
authority is no binding.
Wait, don't give. See, what has happened is, if he has to decide as to whether he is an eligible applicant, he should have stopped with that. He has gone into the facts. At 1.9, you see, the core contention of the applicant, as we find, is that the expression in relation to the supply of goods or services or in both in clause A of 95 is to be interpreted in such a manner to include both outward and inward supply so as to entitle the applicant to file an application as recipient of service. See, the act does not make whether a distinction whether he's a service provider or a recipient.
I'm grateful to your lordship. That is the precise reason why the honorable single judge, because he has gone into the facts and then went on to say that he is a recipient of service and he, my lord, advance ruling cannot be granted in his favor. The honorable single judge, my lord, has rightly, my lord, asked the petitioner to approach the appellate authority, granted him liberty to approach the appellate authority under section 100 by condoning the delay of 30 days, my lord.
But
because the facts has to be examined.
If he falls within the definition of applicant under 95C, and the issue which he agitates falls within 97(2)(b.
Right.
Matter is over.
That is.
Let him decide the matter on merits.
Your lordship, kindly.
This intra-court appeal has been filed by the writ petitioner against the order dated 5th April 2023 in WPA 6251 of 2023. The appellant filed the writ petition challenging an order passed by the West Bengal Authority for Advance Ruling, Goods and Services Tax, within bracket Advance Ruling Authority, no, within bracket AAR, bracket close, dated 9th February 2023, by which the application filed by the appellant for an advance ruling was rejected on the ground that the appellant has no locus standi to file such an application. The reason given by the, the learned single bench by the impugned order has relegated the appellant to the appellate authority under the Act to agitate the correctness of the order passed by the AAR. Aggrieved by such order, the appellant has preferred the present appeal. We have heard. The AAR in the order impugned in the writ petition has not gone in, has made a slight attempt to go into the merits, go into the aspect as to who is the applicant before the AAR seeking an advance ruling, and concluded that the appellant, being a recipient of service, is not entitled to maintain an application before the AAR. Under the provisions of the Central Goods and Services Tax Act, 2017, within bracket the Act, in section 95, within bracket C, the term applicant has been defined to mean any person registered or desirous of obtaining registration under the Act. Thus, in our view, the said term has been defined in the most widest possible manner to include any person registered or desirous of obtaining a registration under the Act. Undoubtedly, the appellant is registered under the provisions of the Act. Section 97 of the Act deals with application for advance ruling. Subsection 1 states that an applicant desirous of obtaining an advance ruling under the relevant chapter may make an application in such form and manner and accompanied by such fees as may be prescribed, stating the question on which the ruling is sought. Subsection 2 deals with the questions on which advance ruling is sought under the Act. Deals with the question on which advance ruling can be sought for under the Act. The application filed by the appellant would fall under clause B of section 97 within bracket 2, as the appellant seeks for a ruling as regards applicability of a notification, exemption notification, number 12/2017 -CGST within bracket R, dated 28/6/2017. If that be the case, it will be well within the jurisdiction of the AAR to consider the application on merits rather than rejecting the same on the ground of lack of locus standi. As pointed out, the appellant clearly falls within the definition of applicant as defined under section 95 within bracket small c of the Act. Therefore, we are of the view that the application filed by the appellant before the AAR has to be decided on merits. For the above reason, the appeal is allowed, the order passed in the writ petition is set aside. Consequently, the writ petition is allowed and the order passed by the AAR dated
9 February 2020.
9th February 2023 is set aside and the matter is remanded back to the West Bengal Authority for Advance Ruling to decide the application on merits and in accordance with law. We make it clear that this direction has been issued considering the facts and circumstances of the case on hand.
But time period may be given 8 weeks.
We don't know what is their pressure of.
Why? We'll apply. Grateful to you.
Item number 5 and 6.
You add in between. In a moral, in case of Gayatri Projects Limited and another versus Assistant Commissioner of State Tax, Durgapur charge and others, in MAT number 2027 of 2022, dated 5th January 2020, this court had taken note of the section, taken note of section 95 capital C and held that the act defines applicant to mean any person registered or desirous of obtaining registration under the act. And in the said case, the appellant being a registered dealer under the provisions of the act would fall within the definition of applicant as defined under section 95 within bracket C of the act, though the appellant therein was not a party to the proceedings before the AAR. This one paragraph you had. Next.
Item number 5 and 6.
Appear for the appellate.
I appear for the.
My lord, on the last occasion, my lord had indicated that it's been applies for directions. My lord was pleased to say, my lord will fix a date for hearing in this matter. My lord, the affidavits and all of exchange, it's ready for hearing.
Our joint prayer is that also kindly fix the matter on 12th.
Oh, challenging the order of the board. Sometime in June. It can't be.
Because the hearing it will not take much time. Because the issue is that the settlement commission the notification used on 1st February 2021. They have filed application on 17 March 2021. Now that application has been rejected by the settlement commission. A short question of law involved. No much time will take.
The provisions of section 153A along with 132 will have to be read. And we say that when the search was initiated under section 132, that is the point when the list started. So 153 is only applicable when search was initiated. So a notice under 153 is consequential. If a search has been done, then 153 notice has to be. And in the meantime, the settlement commission had become abolished. So because he did not issue a notice, my application could not be processed.
That is.
So my lord had to.
Now, what is the relief you sought for in the writ petition?
Back and
We
file.
wanted our application. My settlement commission had rejected our application.
Yes, now the settlement commission is not there.
And we have an interim board now.
They have.
No, interim board issued notification to the effect that those application has been filed before 31st January 2021, and those application had not been disposed of. On that issue, the interim settlement board has been prepared. Some application kept pending because from 1st February 2021 the settlement commission did not operate. Now some application was pending. The interim board constituted for the purpose of that the pending application which are pending before the settlement board, that will be disposed of no new application. Well, it is admitted case in this case they file application on 17 March 2021 after cessation of the settlement commission. Well, their case is that as the notice of under section 153 issued later on the proceeding has been started, but at that point of time there is no settlement commission.
That is the question which has to be answered. So my laws which we have read. And that constitutional, that circulars also on the challenge, we challenge the
It will not take too much time.
We don't know, sir. Since appeal, the learned advocates on either side submitted that the appeals may be heard finally. List the matter on 16th June.
One thing, may I inform Lordship, there is a order from the Government of India. The income tax department has been taken from the Ministry of Law and Justice.
It is.
They will operate from their own. 2 days back, the notification has been issued.
Very good. Then matters will be much easier. Next.
Item number 7.
No, 5 and 6.
5 and 6.
Lordship, this is that matter wherein your lordship had provided a stay and asked CGST department to seek instructions wherein they were on the same amount I had paid GST and WB GST authorities had done an investigation and substantial amount was already paid as GST. Now service tax department after 5 years by invoking extended period of limitation basis my 26 AS, my income tax return, they stated that this activity is taxable to service tax. So the consideration which I received for the work done in the pre-GST period, but consideration received in post-GST period, they charged me service tax on the entire value. On the same value, state GST authorities had taken GST from me.
No, what we have said is, the question which is involved in this appeal is whether department having recovered GST at 12% and all receipts reflected in the profit and loss account of the appellant for the financial year 17-18, whether service tax could have been demanded on the entire amount at 15%. In spite of the assessee having pointed out that this would amount to double taxation. Mr. Uday Shankar Bhattacharya is direct to get specific instruction in this regard. What is your instruction?
My instruction is that, my lord, the works was completed before GST came into effect, 1st July. Therefore, he is liable to pay 50%, my lord, of service tax of the entire amount.
No, he is
Apart from
already
that,
paid 12%.
My lord,
He is already paid 12%. And you are on the entire amount, you are demanding 15%. If for the period of, post GST regime, whatever has not been paid, then if there is a demand, let us see the order in original.
That is at page 271. It starts at 271. And the relevant finding, lordship, regarding this point is at page 306, para 5.4.19. 306, lordship, wherein the adjudicating authority deals with the paragraph.
my lord, kindly takes, my lord, from 289.
Lordship, can I submit one point? Lordship, what has happened in similar matters? This PWD department, this Singur rehabilitation project there were around 25 contractors. Thus, when the tender was floated, lordship, because it was a short notice tender, though service tax was there. Post facto approval was given by the PWD government of West Bengal that, okay, all the contractors will get service tax. So we didn't pay service tax because we didn't receive. Now when GST came, lordship, a GST investigation happened to me. They told, no, you have to pay. We paid under protest and we are into appeal. We have paid that amount. Lordship, but the major factor, which was my prayer before learned single judge also, was that this matter first, the PWD, the state, the chief secretary has to take a decision whether I am eligible to get service tax or not. This 97 lakhs, which is being demanded by the service tax authority, lordship, it has to be appreciated. It's an indirect tax. I have worked for the government. The contract is, it is a post facto approval which has been given by the government that all the contractors will get service tax from the state. Lordship, it is at page number 230, wherein the post facto approval is there, lordship. Page 228, lordship. Eligible copy is at lordship, page 212. Lordship, it is by the government of West Bengal PWD to the chief engineer PWD. It says, lordship, post facto administrative approval for the project demolition of shed. I'll read the first paragraph, lordship. The undersigned is directed by the order of governor to say that the governor was pleased to accord post facto administrative approval for the project work demolition of shed and this low areas at Singur, Hooghly, and disposal of dismantled material to government stock yards at Singur, Dankuni at an estimate cost of rupees this 100 and what is this? The change of this account will be debited to this account. This order is issued with concurrence of finance department. Next, lordship, page 213. it is the list of the total contractors who are involved. There are total 64 line items from page 213 to 227, in which I am also there, Lordship, at serial number. At page 214, Lordship, first 4 serial number is my name, Amar Construction. So, Lordship, then at page 228 is another approval for certain balance amount. So, the moot question goes that I have not received service tax from the state, which I have to receive. The dispute whether I pay service tax or I pay GST, it's an indirect tax. But unless I don't receive, how do I pay it? They have recovered, and when the GST proceeding started, the DRI Department of the State Investigation, they recovered by debiting my ledgers. So indirectly, I paid more than 70% there also, which I am in appeal. So the moot question that has to be decided, Lordship, that I have to first receive this. And similar in case of Biswas construction.
But PWD or the state government was not heard by the authority. This adjudicating,
He was not heard, but he has given his remarks at page 306, Lordship. That is his only remarks. In fact, Lordship, this is the second round of litigation before your Lordship for this matter. In the first round, we had written to PWD to reimburse. They didn't pay us. And I received a show cause. Then your Lordship directed the adjudicating authority to make PWD a party, hear them out, and then pass an order. So the London adjudicating authority called them. We had a joint hearing, and then this order in Ohio was passed.
he doesn't refer to the stand taken by PWD.
Lordship, he is not. But Lordship, the stand of the government of West Bengal is very clear. They have given a post facto approval.
Correct, but when he appeared and if he had produced those papers, the adjudicating authority should have dealt with that.
Lordship, to that section, he says there is no other, Lordship, that at page number 306, that is his main finding. Page 306, para 5.4.19. So, Lordship, my humble prayer would be to keep this proceeding in abeyance and first let the ACS, Government of West Bengal, decide whether I am eligible to get service tax or not. I have written, after your Lordship's order, after this Ohio, we have written n number of letters to them. But nobody is giving us any payments. They say unless the court orders, we cannot. Lordship, similar matters. In case of when the London single judge, notification 50/50 was issued by the state of West Bengal for works contract when the GST came in, for the rate of change in GST. So it was directed to that the London ACS would take a decision whether an enhancement of rate is required because of GST. And there are around 40 cases which the London ACS has disposed of. We have got increments also.
ACS means what?
Additional Chief Secretary, Finance Department, Government of West Bengal.
But they are not a party here.
Lordship, we have written the letters to them, Lordship. The letters, I can take you to the letters which was written to them. Post, when we received the show cause notice, Lordship. That letter is at page number. We have written to the, it starts at page 168, Lordship. We have written to all the parties, the respective parties is at page 171. Including the CGST department and the state tax commissioner, everybody. There were various letters exchanged, Lordship. Lordship, in light of page 212, wherein the post facto approval has been given by the government for the same contract, let it be decided by the government of West Bengal as to my eligibility of service tax reimbursement. Today, the central government, the CGST authorities are already secured because they have already recovered 80% of the amount.
Now, what is this representation at page 168?
Lordship.
Is addressed to the executive engineer.
And Lordship, it is CC at page 171.
All right. Now, what is the stand of the executive engineer?
Lordship, next, Lordship, his stand is, I'll take you. That is at page number. Now, Lordship, after that, page 187 is my second representation. Where I refer to my earlier letter, which is at page 187. It is 19.5, that was 6.5, Lordship.
Then what will be your stand in this? No, if you pay him, he will pay.
The contract. He has to challenge the contract.
No, he refers to some post facto approval
By the state.
by the state.
Lordship, page
At least
202.
you should have rejected his representation or passed some order.
Lordship, page 202 is the order. Lordship, page 202 is what PWD states. They accept the liability, Lordship. Lordship, page 202. He says, now this is to be mentioned that Amar Kansha has not raised any claim of reimbursement of service tax. So I will not pay. Lordship, what about the post facto approval? It's a government of West Bengal. When the West Bengal government is stating it is, you are eligible to service tax.
That issue need not be decided if you decide this issue. You dispose of this representation, we'll keep the matter pending. You pass an order.
Whether I'm
Third.
eligible for the
Third respondent, executive engineer. He has to take a stand.
Lordship, executive engineer.
Respondent
Respondent number 3.
We have heard so and so. Before a decision is taken as to what relief the appellant would be entitled to in this appeal, we require a clear stand to be taken by the third respondent, namely the executive engineer, Hooghly Highway Division number 1, Public Works within bracket Roads Directorate, Government of West Bengal. The petitioner, the appellant has been making several representations to the third respondent with a request to make payment of service tax payable in respect of the letter of acceptance cum work order dated 21/9/2016, 22/9/2016, 23/9/2016, etc. etc. The applicant has submitted representations through their counsel, the first of which is on 6th of May 2022. The case of the appellant rests upon a post facto approval granted by the Government of West Bengal dated 6th of June 2017. Therefore, before we proceed to hear the matter, the third respondent is required to take a decision on the petitioner's representation. Therefore, we direct the third respondent to consider the petitioner's representation sent through their counsel dated 6/5/2022. And where is the second representation?
It is at 19.5. The date is 19.5. Lordship, it is at page number 187, Lordship.
And 19/5/2022. After affording an opportunity of personal hearing to the authorized representative of the appellant, the third respondent is directed to pass a recent order on the representation, and after such order is passed, the appeal will be taken up for consideration. The interim protection, this direction be complied with by the third respondent within a period of the third respondent is directed to comply with the above direction within a period of 3 weeks from the date of receipt of the server copy of this order. It will be well open to the third respondent to take the assistance of the finance department or any other authority, or even and also consult the CGST authority if need be. The interim full stop. The interim protection granted on 21/12/2022 shall continue. List the matter in June.
So just one indulgence, Lordship, it can be mentioned that in line of the post facto approval.
We have said post facto, he'll take a decision.
Grateful.
Item number 8.
I beg to appear for that. May I submit the affidavit and reply, my lord? May I submit?
On what ground your appeal was dismissed?
My lord, appeal dismissed, my lord, on the ground of limitation, only sole ground of limitation. My challenge is that, my lord, appellate order as well as, my lord, adjudication order. Because, my lord, there are several issues. Adjudication order passed in violation of principle of natural justice and without issuance of show cause notice, my lord. That I will show you, lord. My lord, the first respondent, my lord, on the 5th March 2021, issued pre-ACN at page number, my lord, 83, my lord, of the stay petition.
33.
83, my lord.
83.
83.
Yes.
And my lord, thereafter I have submitted, this is pre-SCN, my lord, GST DRC 01A. I have submitted, they issued through email. I have submitted reply on 8th March. Next page, my lord, 84, 85. I have submitted reply, my lord. Thereafter, my lord, what happened? Respondent number 1 did not proceed with the matter, nor issued show cause notice, nor pass any order. Thereafter, on 30th March 2021, the respondent number 2 issued DRC 01A under section 74, my lord, at page 92.
86.
Page 92, my lord.
92.
92. Through email. And thereafter, my lord, after long gap, on 16/9/2021, at page 94, my lord, they issued DRC 01 under section 73. So they changed the section, and mandatory requirement is that, my lord, as show cause notice under section 73 has to be issued. Though they issued pre-show cause notice under section 74, and they issued DRC 01 under section 73. And, my lord, they violated rule 142 1A because one show cause notice along with DRC 01 has to be issued. Here no show cause notice issued, my lord. Thereafter, they passed the order, my lord, on 3rd December 2021. And, my lord, first, here one thing, my lord, they first issued all the notices through email, and I have submitted through email. Thereafter, this is the first time GST notice. So petitioner somehow missed that notices, my lord, and passed the order. Thereafter, my lord, what happened? The order at, my lord, page 97.
Yes.
Page 97, my lord, this order has passed. Thereafter, my lord, what happened? On 20th October 2022, the respondent number 2 recovered 1,84,930 from my electronic credit ledger at page 102, my lord. And this is, my lord, my date of knowledge, my lord. I came to know, and thereafter I have contacted with the department, and very next day on 21st October 2022, applied for certified copy and filed appeal on 22nd October 2022 at page.
Now we'll come back to the first point.
Yes, madam.
Page 94.
Yes, madam.
This is form GST DRC 01.
01, madam.
Issued under rule 142 1A.
Yes, madam.
According to you, prior to this, there should have been a show cause notice.
Yes, madam. May I show the?
Sir, that GST book.
My lord, I am giving one.
It is there. You give that and take out.
Yes.
This is section 97, is it?
No, my lord, rules.
One more book, Lordship.
Rule my lord 142 1A, my lord. This CGST my book and SD same similar provision. May I read, my lord?
For Lordship book custody. Yes. 142, notice and order for demand of amounts payable.
Payable under the act, the proper officer shall serve along with the A, notice issued under section such and such 73 or 74, such and such, a summary thereof electronically in form DRC 0101. That means notice along with DRC 01 has to be issued. And Honorable High Court of Jharkhand, my lord, and similar issue decided and quashed the order, my lord. I will show you, lordship, the judgment, my lord. And my lord, personal hearing, my lord. Kindly see, my lord, section 75, subsection 4, my lord. (75) subsection 4.
Yes.
My lord. An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, comma, or where any adverse decision is contemplated against such person. So even I have not submitted request for personal hearing. Personal hearing is mandatory, my lord. Honorable Delhi High Court and Bombay High Court.
No, page 94 is a summary of the show cause notice.
Page 94 is, my lord, summary of show cause notice.
Yes, that's what it says. A summary thereof electronically in form GS DRC 01.
01.
Yes.
This is okay, my lord. But one show cause notice along with the summary of show cause notice has to be issued, my lord.
Shall serve along with the notice issued under section 73 or 74.
Yes, my lord. So
no, this according to you, this was not accompanied with the show cause notice.
Yes, my lord. Show cause notice with, my lord, DRC 01. That has to be issued, my lord. May I submit, my lord, the judgment?
Now, after you received this page 94,
yes,
you have not addressed the assessing authority to give you an opportunity.
No, my lord, because that order only uploaded in the portal, my lord, not sent through email, and that's why, my lord, I missed that. This is the first time GST case, my lord. That's why I missed the case. And after recovery of electronic credit ledger on 20th October 2022, I have filed the appeal on the 22nd, my lord.
So, the notice, I mean, all other earlier notices were also through email. How you missed this alone?
First notices issued in email by respondent number 1, and I have submitted reply. Thereafter, he did not proceed. And during pendency of appeal, that respondent number, first respondent.
Which appeal?
This statutory appeal.
Oh.
Respondent number 1 issued DRC 01. Again, no show cause notice issued. Same office, same respect.
Let us see the first DRC 01.
Yes, ma'am.
Page number?
First GRC 01, my lord, at page 83. (83), my lord. And there is also another violation, my lord, in this notice, because rule 26 sub rule 3 says digital signature has to be there. The no digital signature is there, my lord.
But in this notice at page 83, it says, you are hereby advised to pay the amount ascertained, etc. Sir. Failing which show cause notice will be issued under 73(1).
Yes, ma'am. So I have uploaded, I have sent through email part B, my lord, 84. Then I have sent.
This was not disposed of.
Not disposed of, and during the statutory pending of appeal, that first respondent issued DRC 01 without show cause notice on 7/11/2022 at page number, my lord, 114. Thereafter, I have written them, My appeal is pending, same subject, same case, same period. So you are requested to withdraw the matter, withdraw the case. Thereafter, my lord, they did not close the matter. But after submission of the affidavit in reply in page 13, they are showing that, you know, after receive of request on 24th March 2023, they closed the order. But they did not close the order, my lord. Kindly come have a look, my lord. Affidavit in reply, last page, my lord, page 13.
Now let us see the appellate authority's order. Where is the
Appellate authority order, my lord, at page 122, my lord. Operative part is, my lord, at 124. May I read the last para? 124. In the light of prior discussion, it is crystal clear that appellant utterly failed to cater any possible explanation behind the sitting idle long time after passing the order communicated on 3rd December 2021. On the other hand, the appeal has been conditioned by a specified time limit statute as per the provision of ATO 107, read with section 107 of the State Act. I want to opine that an ambiguous manner that the statute does not permit me to accept the instant appeal application, and appeals rejected. And my lord, there is 147 days delay if I consider the COVID limitation period after 28th May 2022. There is 147-day delay, my lord.
but he can't condone it. The statute doesn't permit him to condone.
But well, in many matters.
But according to you, limitation will start running from the date of knowledge.
Yes.
In page 123, he says that the order was communicated to the appellant on 3/12/2021 as per statutory provision invoked. In the reply, the appellant remained totally silent regarding receiving the same through common portal. On the other hand, from the copy of the letter dated 21/10 as submitted before the respondent proper officer, it transpired that they had earlier submitted reply to so and so at the initial state of the related proceeding, depicting their awareness, knowledge regarding the matter proceeding concerned.
My lord, only after.
But the original notice, they did not proceed.
No, my lord.
What do you say, Hon'ble? Original notice, he had promptly sent a reply.
The first notice, my lord, which was issued, which has been shown to your lordship at page 83.
That the authority sought to revive during the pendency of the appeal.
No. He asked for dropping that proceeding. That proceeding was dropped by the respondent number 1. Thereafter, the respondent number 2 initiated, my lord, this is GST DRC 01A. Intimation before the show cause notice. Your lordship was looking at the provision. Lordship, may kindly turn to section 73 first. The law, first of all, my lord, kindly get the law clear, my lord. Section 73. There's a substantive provision. Section 73(1) is the provision for issuance of show cause notice, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where the input tax rate has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement or suppression of facts to evade tax. He shall serve notice on the person chargeable with tax which has not been so paid or which has not been short paid, or to whom the refund has erroneously been made, or who has wrongly availed or utilized input tax rate, requiring him to show cause as to why he should not pay the amount specified in the notice, along with interest payable thereon under section 50 and a penalty leviable under the provisions of this act or the rules made thereunder. Prior to that, section 73(5), subsection 5. An intimation can be sent. The person chargeable with tax may serve before notice of service of notice under subsection 1, or as the case may be, the statement under subsection 3, pay the amount of tax along with interest payable thereon under section 50 on the basis of his own ascertainment of such tax, or the tax as ascertained, or by the proper officer, inform the proper officer in writing of such payment. So this is the intimation which is issued in GST DRC 01A. Initially, this intimation was issued on section 80 at page 83 on 5th of March 2021.
Exactly, correct.
The petitioner replied to the same on 8th of March 2021, asking to drop.
Please take page 83.
Page 83.
After giving the grounds of quantification, last paragraph. You are hereby advised to pay the amount of tax as ascertained above with the amount applicable interest, penalty under so and so, failing which Show cause notice will be issued under 74.
74. So 73, 74 are perimeter provisions. Perimeter provisions.
So he has given some reply,
He has given
but the
reply.
authority did not proceed further.
So the authority dropped the proceeding.
No, dropping took place during the pendency of the appeal.
No, it was dropped. If your lordship kindly sees, but he has not.
Drop maybe on your file, not to the knowledge of the SSC.
It was.
So if that is so,
in
you
their
should have taken this proceeding to the logical end. Parallelly, now the second proceedings has been initiated by the second respondent.
Which was GST DRC 01A was issued. Then again on 30th of March 2021, which is at page 92. Page 92. This is the intimation of tax first, my lord. At page 92.
Here also it says, failing which show cause notice will be issued. Why did you not issue show cause notice?
No, he did not reply. We issued show cause notice at page 94. Everything is there, my lord. We issued show cause notice at page 94 on 16th of September 2021 in form GST DRC 01.
This is summary of show cause notice.
Your lordship kindly sees the next page, page 95. Copy, your lordship, after the table, my lord, your lordship kindly sees copy of detailed notice is enclosed as separate attachment. Now your lordship kindly sees the next page, inadmissible input tax credit on certain inward supplies. It was given. Thereafter, the summary of the order has been passed. This order on 3rd of December. This is the summary of the GST DRC.
His case is this page 94 was not to his knowledge.
That is what now your lordship kindly turns to the
page 94. He was not aware
your
of
lordship kindly turns to two provisions, my lord, of the GST Act. Lordship kindly sees section 169. Service of notice in certain circumstances.
That is different, man. Students of a show cause notice is one thing and service is different.
No, according to the government leader, summary of notice is the show cause notice.
Rule says
along with a detailed attachment also, because there
it says with attachment.
This is the attachment of details of facts and circumstances, but notice has to be issued, my lord. In several other cases, my lord, this is the I have seen in first time in this case.
My learned friend was beating about the bush. I'll just conclude my argument, my lord. Your lordship kindly sees section 169, my lord. This is with regard to service of notice. Any decision, order, summons, notice, or other communication under this act or the rules made thereunder shall be served by any one of the following methods, namely by giving or tendering it directly or by a messenger. B is by registered post. C is by sending a communication to his email address, and D is by making it available on the common portal. And all these are with or. This is. And now lordship may kindly trust. Bole din tapar tumi bol de. Lordship may now kindly turns to section 160 subsection 2. 160. Section 160 subsection 2. Heading is assessment proceeding, etc., not to be invalid on certain grounds. Subsection 2 speaks, my lord, the service of any notice, order, or communication shall not be called in question if the notice, order, or communication, as the case may be, has already been acted upon by the person to whom it is issued, or where such service has not been called in question, or in the earlier proceeding, comments continued or finalized pursuant to such notice, order, or communication. And he filed an appeal, my lord, and there is, my lord, the case rests on that was an inordinate delay of 10.5 months in his appeal. Now, my lord is trying to make up a case that it was not communicated to me, it was not there in the portal, the attachment was not there, everything was there, my lord. GST DRC 01A was issued initially, thereafter GST DRC 01, that is the show cause notice, and thereafter the final order, because he did not reply to the intimation notice, he did not reply to the show cause notice.
Then you could have, all right. Then if it is so, you should have considered his first reply. You could have taken note of his first reply.
We considered his first reply and dropped the proceeding. Thereafter,
on what date you dropped the proceedings? He says it was dropped during the pendency. His reply after it.
Which reply, my lord? Last page, my lord. 13, page 13.
Page 13, my lord.
Kindly see, my lord, the watermark and date, first date, 24th January 2023.
This is there in the portal.
And during pendency of statutory appeal, they have issued notice on 7 November 2022, and we have submitted reply 17 December 2022 for dropping they drop on 24th
No, no.
January 2023. First page, first line, my lord.
This is the, this
My
is
lord.
the date of the final report.
My lord, this is not
The date
drop.
of,
This is not, because my lord, kindly see the watermark. This is written draft. That means they prepared and keep their portal pending and not uploaded in my portal nor communicated through email. I have personally checked, my lord, this notice in GST portal and also the email ID of the client, my lord, to ascertain the genuineness of this document. Because watermark says draft.
this is draft with regard to the final
When
report.
prepared, they can keep themselves as draft. When upload, then draft omitted and my lord omits, and then some other watermark comes, my lord, there.
So the first proceedings was, even according to you, your stand was dropped only on 24th January.
No, 24th January 2023, my lord, is the final report. My lord, the first proceeding was dropped. My
Yeah.
lord, I have stated in my affidavit, my lord.
Let us see on what date you have dropped. Affidavit in opposition. Page number 13 of the affidavit in
Page
opposition.
number 13 of the affidavit.
It is 24th of January 2023.
It is the final, it is the
Ah.
final report with regard to the entire proceeding.
Sir, final report is what is being uploaded.
Ah.
So on the date when you drop the proceedings, the appeal was pending as against the second DRC 01E, whereas the first proceedings was not taken to the logical end. So therefore, matter should be decided on merits.
My contention only is recorded in paragraph 2B of the affidavit.
You are 100% right. Procedure 160, 169, he can't raise a defect, etc. But this issue is there.
This issue is there, my lord. But my contention is recorded in
No, on the legal issue, you may be right. Now,
but even with regard to delay.
now the second, that is page 94 DRC 01 was issued by the second respondent, is it?
Yes,
And
my-
who issued it?
Respondent number 2, my lord,
2,
the deputy commissioner.
Deputy Commissioner. The first was issued by the Assistant
Assistant
Commissioner.
commissioner, same office, respondent number 1, assistant commissioner. And this deputy commissioner.
Mackenzie Lane, same office.
Yes, ma'am.
Next table probably.
And my lord,
Deputy commissioner is higher in.
But he is in the 6th floor, probably he is in the 5th floor.
and my lord, in
But
this,
my contention is recorded, my lord, in paragraph 2.
We'll send it back. Please come. This
Paragraph 2B of the affidavit.
my lord, judgment not recorded.
I have got
we'll
judgment.
send ask the appeal to be decided on merits.
And my lord, appeal, my lord.
Your appeal will be, the order will be set aside.
And my lord, as I have paid 10%, my lord, my electronic credit ledger amount, my lord, 1,84,000,084 may be recredited, my lord.
That order you take before the appellate authority.
My lord, in other cases, my lord, your lordship granted, my lord, in
No,
case
not in
objection
this.
passed, my lord.
This intra-court appeal by the writ petitioner is directed against the order dated 6th January 2023 in WPA 2023 of 2023. I'm sorry, in WPA 29 of 2023. The appellant had challenged the order passed by the Senior Joint Commissioner, State Tax, Howrah Circle. Dated 21st November 2022, rejecting the appeal filed by the appellant as time barred. On a cursory perusal, on a cursory glance of the order passed by the appellate authority, one gets an impression that the order is perfectly legal and valid, as the appeal was hopelessly time barred and the authority had no power to condone the delay in filing the appeal. However, on a closer scrutiny of the facts and circumstances of the case would lead to a different conclusion. The appellant was served with an intimation of the tax ascertained as being payable under section 73 within bracket 5/75 within bracket 5 of the Goods and Services Tax Act, dated 5th March 2021.
74. Section 74.
Seven-
73 within bracket 5 slash
Slash
74.
74 within bracket 5 of the Act, dated 5th March 2021. In the said intimation, which is in form GST DRC, all capital, -01A, the grounds and quantification was mentioned, and the appellant was advised to pay the amount of tax ascertained along with the amount of applicable interest and penalty under section 74 within bracket 5 of the Act by 12th of March 2021, failing which show cause notice will be issued under section 74 within bracket 1 of the Act. The appellant filed their reply to the show cause notice on 8/3/2021. The matter was not adjudicated further and kept pending. The said intimation dated 5th March 2021 was issued by the first responder. Thereafter, the second respondent issued form GST DRC 01 within bracket under rule 142 within bracket 1 within bracket small a of the GST rules bracket close, dated 16/9/2021, which is the summary of the show cause notice. The summary states that the copy of the detailed notice is enclosed as a separate attachment. The case of the appellant is that he was not aware of the said notice being uploaded in the portal, and they came to know of the same only after the sum of rupees 184,930 was debited from their electronic cash ledger. Immediately thereafter, the appellant applied for a certified copy of the order, and thereafter preferred the appeal. And by then, the period of limitation for filing the appeal had expired. The crucial issue would be as to whether the second respondent could have initiated fresh proceedings when already the first respondent is seized of the matter, and notice in form intimation in form GSTR DRC 01A dated 5/3/2021 was issued, to which the appellant had submitted their reply dated 8/3/2021, and the said reply was neither considered nor rejected, and the matter was kept pending. The option which was available to the first respondent was to consider the representation/reply, and if not satisfied, could have proceeded to issue show cause notice under section 74 within bracket 1 of the Act, which option the first respondent did not exercise, and the matter was left to linger. Thus, a parallel proceedings could not have been initiated by the second respondent when the first proceedings initiated by the first respondent for the very same period and the very same amount with the very same allegations was not taken to the logical end. After full stop. When the statutory appeal was pending before the appellate authority, the first respondent had dropped the proceedings. It is very crucial to note that from the final report submitted by the first respondent, final report of the first respondent, it is seen that the proceedings was closed by the first respondent only on 24th January 2023. Thus, for all purposes, it is deemed that the first proceedings initiated by the first respondent pursuant to note intimation dated 5/3/2021 had attained finality only on 23/1/2022, and on the said date, the appeal as against the second proceedings initiated by the second respondent was already pending before the appellate authority. Therefore, considering the peculiar facts and circumstances of the case, we are of the view that the appeal should not be treated to be as time-bound. More particularly when the appellant had responded to the first intimation dated 5/3/2021 and submitted their reply on 8/3/2021, which was not considered or disposed of. Therefore, the issue as to whether the appellant did not notice the uploading of the form GSTR, the GST DRC 01 dated 16 September 2021 from the portal or not has become an academic issue. And in the peculiar facts and circumstances of the case, we are of the view that the appeal should be decided on merits. For the above reason, the appeal is allowed. Consequently, the writ petition is allowed, and the order passed by the appellate authority, namely the Senior Joint Commissioner, State Tax, Aura Circle, dated 21st November 2022 is set aside, and the appeal stands restored to the file of the appellate authority with a direction to hear and dispose of the appeal on merits and in accordance with it. We make it clear that this order has been passed considering the peculiar facts and circumstances of the case. The learned advocate appearing for the appellant submitted that whatever the excess amount which has been swiped off from the electronic credit ledger of the appellant should be recredited. Such prayer can be made before the appellate authority, which shall also be considered by the appellate authority.
Personal hearing, my lord, one line may be added, my lord.
Needless to state that the authorized representative of the appellant be afforded an opportunity of personal hearing. Virtual or
No, physical.
personal hearing. Next.
I'm grateful.
Item number 9.
Wait, please, my lords. Waiting for the appellant. We have filed an application in the matter. May I briefly encapsulate the facts? This is the matter where, my lord, there was a direction from your lordships.
No, you said it has not been credited.
It has not been credited, my lord.
Marada,
That is
it
the
has been
stand.
credited, my lord.
How it is credited?
That is my lord.
My lord, it has not been credited. It has not been credited. My lord, kindly takes up, my lord, page 12. That is the last.
No, what is this order?
This is, my lord.
You read it and ask, get instruction from your client. He is standing there. The undersigned hereby recredits into the taxpayer's electronic ledger the following amount paid by and recovered in cash in compliance with the above order of the Honorable Division Bench. Now, when you will pay the balance?
But my instruction is, this is the amount, my lord, 2,60,000 is the amount of recovery that the department has made. It is not, my lord, the amount which they have paid.
They will do it. They will do it. They have.
Also,
Your allegation was this was not done on the last
my lord,
occasion.
my allegation is that the 6 lakh rupees and the 5 lakh, which my lord we have already paid, has not been recredited.
When you will credit that
That is
11
the-
lakhs, you credit that.
11 lakhs rupees, my lord.
See, if you don't do that, then there is no problem, purpose will be served by directing him to keep on paying.
The very day they do that, my lord, within the next 10 days, my lord, we'll make the
But
deposit.
the 11 lakhs to be paid to them under the WBGST.
Yes.
But that
The
is
last
not
order.
fair.
Page 12, the last order.
If you see the order,
The last order passed by your lordships is at page 12 of 27th February.
Actually,
excluding interest, the amount which was originally payable was 25 lakhs. We directed payment of rupees 10 lakhs not later than 31st March 2023. I with the direction to the department to credit all payments which have been made by the appellant, that is this 2,60,217, and which have been made by the appellant and to be made by the appellant to the credit of the same and the electronic credit ledger. This direction will also apply to rupees 6 lakhs and odd, which was initially paid with the appellant, and a sum of rupees 5 lakhs which was paid pursuant to the direction of the court on 15/2/2020.
This has not been credited, my lord.
my lord, may I, my lord? My lord, let me come with my lord, a short kind of an affidavit within a week, my lord. My lord, my lord,
No.
why 6 lakhs not been paid, why 5 lakhs not been paid? But because my lord, this instruction said, my lord, some amounts has been paid. What is electronical credit ledger has been my lord,
No,
credited.
the officer has referred to the order dated 27th February. But he should also, having referred to that,
He should also, my lord, recredit the 11 lakhs also.
yes.
And my lord, my instruction is also that this amount is, my lord, the amount of recovery. This is not the amount which is paid to
Paid,
the
it's
credit
not
ledger.
been paid.
It is not.
No, the 10 lakhs you have paid, no.
But we have paid
Huh?
5 lakhs and 6 lakhs. So 11 lakhs we have paid.
11 lakhs you have paid.
We have paid, my lord. And there was a direction, my lord, that we need to, my lord, again pay 10 lakhs by 31st of March, which, my lord, we had then mentioned. And my lord, now
Okay.
I'm praying, my lord, that period be extended if, my lord, my learned.
No, let your learned friend get specific instruction. We have heard so and so. In terms of the earlier direction, the amount of rupees 6 lakhs and odd and rupees 5 lakhs paid by the appellant has not been credited to the electronic credit ledger of the appellant. And therefore, a direction was issued to the respondent authority to credit the said amounts. The learned government council has produced before us a communication received by him from the joint commissioner, which shows that an amount of rupees 260,217 has been credited to the appellant's electronic credit ledger. However, the same does the said communication does not refer to the crediting the amounts of rupees 6 lakhs and odd and rupees 5 lakhs, which was directed to be done. The learned government council requests a week's time to get specific instruction in this regard. The direction to the appellant to pay a further sum of rupees 10 lakhs stands extended till the next hearing date.
I'm deeply obliged.
List the matter on next Friday, 28th.
I'm
Yes,
deeply obliged, my lord.
Great flush. Officer ke deke badachhi. Kya question bushe.
Item number 10,
Yes.
My lord, Mr. Vipul Kundal is appearing for the respondents. My lord, he is not in Calcutta. He had to leave, he had to go to Ahmedabad for dealing with a medical emergency in his family. So my lord, kindly adjourns this matter.
My lord,
Defects have been rectified.
my lord, the difficulty is this, my lord, this is a very small SSC, income having less than 50,000, my lord. And the reopening is being sought to be affected
on change of opinion. On the self same region, my lord, already 143.3 assessment has been passed. We have made our submissions. Still, they have not dropped the proceedings, my lord. And now the two so-called notices have been issued to us. One, the last opportunity variation proposed of a sum of 54 lakh. That is, yesterday they have issued, my lord, and only 4 or 5 days has been given to respond.
Yesterday they issued another notice.
Another final so-called notice proposing a variation of 54.77 lakh.
Then what happens to this notice?
My lord, D order has been passed. 148A
AD order
has been passed. Learned single judge has dismissed my writ
So
petition.
based on that, they have issued a 148 notice.
No, based on that, now 142.1 and other their regular
Reassessment proceedings has started.
And now final so-cause to make reassessment and to make addition of 54 lakh. That has been, this is a very small trader, my lord. Only few 2-3 lakhs income is there.
Then you should not proceed if you want an adjournment.
My lord, kindly keeps it on Wednesday when.
But in the meantime, if he
Tuesday is the last date to respond, my lord, and Wednesday he will pass an order.
And he will upload the order.
And it is faceless, my lord. I cannot go and meet him also.
Yes, we have heard Mr. Subhash Agarwal and so on.
My lord, condonation is there
And
for
Mr.
73 days.
It is submitted by the learned counsel for the respondent that the senior standing of respondent is not in Kolkata and prays for adjournment. The learned advocate for the appellant submitted that pursuant to the reopening proceedings, the assessing officer has issued notices under section 142(1) and also a show cause notice proposing to recover additional tax. List the matter on so and so date, and in the meantime, the reassessment proceeding shall be kept in abeyance. Sometime in May. Next.
Item number 11.
So I'm for the Union of India.
Lord, I appear for the state respondents in this matter. My lord, before my learned friend proceeds in the matter, my lord, there are certain matters, my lord, I do not, my lord, oppose my learned friend in each and every matter. The earlier matter, your lordship passed an order, my lord. My lord, in this matter, my lord, this could not have been decided without affidavit. The honorable single judge, my lord, directed the parties to exchange the affidavit and directed the matter to be taken up in the month of May. My learned friend says that he is squarely covered by a judgment passed by the Honorable Supreme Court in the case of Union of India versus Mohit Minerals. That he was not entitled to pay the IGST on ocean freight on service. So whatever he has paid, it is to be refunded back to him. The judgment of the Honorable Supreme Court in the case of Union of India versus Mohit Minerals is pertaining to the validity of this notification, whether IGST should be paid on ocean freight or services or not by the shipping line cargo. This was only decided. With regard to refund application, nothing was decided by the Honorable Supreme Court. Now it has to be interpreted in the light of the judgment of the Supreme Court. If someone has paid, whether that refund application, whether that refund can be made to him, if that refund has been made beyond the period of limitation.
This appeal is against an order refusing interim order.
There is no scope for any interim order.
What was the interim order?
Because he is seeking a refund, and that refund could have been decided. My lord, there is nothing, my lord, that was an order of attachment or something, any coercive measure was being taken against him. But at the drop of the hat, my learned friend, my lord, prefers appeal. For that reason, my lord, I have objection to this preliminary objection.
Supreme Court in Mafatlal Industries has.
What is the interim order?
Interim order is.
See, you are trying to bring up all these matters here that we can't drag all the petitions.
With due respect, Lordship, with due
Page
respect.
51 and 52, my lord, of the stay application is the prayer in the writ petition.
Before the learned single judge also, Lordship, what was prayed was the adjudicating authority has rejected the refund on the ground that it is a time-barred claim, which is already settled by Honorable Supreme Court in Mafatlal Industries, that when a levy is held to be unconstitutional, the limitation will start from the date when the levy is held to be unconstitutional. I had paid GST in 2017-18.
We will advance the date for filing the affidavit. Whether affidavits have been filed?
My lord, it is ready, my lord. We will file it within a week. We'll
Lordship,
file it within a week.
Lordship, because it's a matter of refund of 2.5 crores, which is already paid. And Lordship, when
There are eight
Maybe
refund applications.
2,500 crores also, no?
Lordship, Lordship, with due
Yes,
respect,
because you should not. This intra-court appeal by the writ petitioner is against the order dated 16th March 2023 in WPA 4373 of 2023, whereby the learned single bench declined to pass any interim orders and directed the respondents to file affidavit in opposition and within a time frame and reply also. On seeing the prayer sought for in the writ petition, which is seeking for issuance of a writ of mandamus to direct the respondents to refund the amount of IGST already paid by the appellant. The question of granting any interim relief during the pendency of the writ petition would not arise. Therefore, the learned single bench rightly declined to pass any interim order. Therefore, the appeal is dismissed. There will be a direction to the respondents to file their affidavit in opposition not later than 27th April 2023, and the appellant is granted 3 days time to file a reply if any, and let the matter be listed during the second week of May 2023 as directed by the Honorable Learned Single Bench.
I'm extremely grateful.
Item number 12. 12 and 13 are analogous matters, my lord. Similar matters, my lord. In both the matters, my lord, have directed the parties to go into mediation, my lord.
Well, I am for the
My lord,
respondent. my lord.
the mediation failed because the other side does not want to tone down even a rupee.
So we have to hear the matter.
My
My lord,
what has happened, my lord, today, since the section 9 has been pending for long, my lord, if there's an arbitration clause admitted, that is probably an admitted fact. If an arbitrator can be appointed, my lord, with the consent of the parties, we have already sent letters invoking the arbitration clause, my lord. That has been invoked. If my learned friend.
Why this? You didn't go attend the mediation.
No, they attended the mediation. They
What
attended
has
the
happened?
mediation. They said that this is what is due, and if you pay us this, we will settle. We won't take a rupee less. This is their stand.
My lord, what is the problem, my lord, we are facing? My lordship, on last occasion also, I have, my lord, addressed before your lordship. Lordship will kindly consider the order dated 31st January 2023. Your lordship was pleased to
No,
pass.
we are just thinking.
Yes, ma'am.
We have heard you on several occasions,
Yes,
and you are confident that something will happen. Should we hear this matter?
My lord, your
No, no.
lordship.
Should we at all hear this matter, or some other division bench will hear the matter?
No, your lordship, my lord.
My
We are
not release the matter.
because this has been assigned. This matter has been assigned before.
We can release it. I will reassign it to
My lord,
somebody.
your lordship, my lord, kindly takes 31st January 2023 order. My lord, lordship will kindly seize the order, my lord, once, man. My lord, FMAT 51 of 2022. My lord, lordship, your lordship, my lord, has observed. Lordship, may I read for your lordship, The learned advocate appearing for the appellant.
That is correct. Then
Yes.
he said, no, he
My
wishes.
lord, your lordship were pleased to dispose of this appeal. Now, what is happening, my lord? Only due to pendency of this appeal. Now, my lord, section 9, we have already, my lord, received an order, my lord, in respect to, my lord, they have, my lord, dispossessed, my lord, they have locked it. Now, they are running it. But we are getting each and every day notices from the, my lord, the building authorities.
Now,
Building authorities
we don't
that
have
pay the
copies.
maintenance.
Should be,
Well,
given
how can I
copies of
pay the
that.
maintenance without being, well, like 45
Why,
lakhs
I
it was
don't
a
know
due.
why they
Now
do
man,
not-
it has exceeded to 50 lakhs, more than 50 lakhs. Now man, the problem is,
now we can say the pendency of the appeal will not prejudice you from taking appropriate.
well, only they have taken the jurisdiction point. On that ground, your lordship was pleased to fix the appeal that they let them come with the jurisdiction point. So there is nothing remains in this
So
appeal.
argue the matter on merits, I'm ready.
But nothing remains.
No, your client is not present here. Never he was present. And we have serious doubts as to the bona fides.
They were present in the mediation, my lord. My lord will. I do not know
what
whether.
was
the
first
first
day they have
I
not-
appear-
were not.
Well, I appear on behalf of respondent number 6, my lord. In spite of repeated requests, my lord, we have not been served with a copy of the writ petition appeal, which is item number 30.
It can be served here and now. They are not part of the arbitration agreement.
When my lord was sitting in courtroom number 16, I have requested before the mediation, I have requested. They have not. They are not
Only I am
served.
seeking before Lordship, kindly dispose of this appeal. They are taking benefits of this appeal. This cannot.
My lord, let an arbitrator be appointed by the concerned.
I am running in loss. I am running in loss.
What it says is, let an arbitrator be appointed.
Arbitrator subject to Lordship, let them file a section 11. They have not filed till, and they have come with a section 21 application. It's a slap.
You pursue that matter. You pursue the matter. You pursue that 11 is pending now.
11
Nothing.
is
They have not filed. They have not
not filed. My, they had themselves agreed that a retired. They had.
We have
agreeable to a
no,
retired
That's
judge.
all gone. That's all gone now.
But my lord, they have given us letters. My lord will kindly have a look for once in the letter written by them. This is written by them, my lord.
These are all letters prior to the settlement your Lordship has sent.
Prior to the
But
settlement,
now
so
the situation
they
is
are-
worst.
Now it's
The license has been cancelled. Everything has been. I am running in loss.
this is March 15, 2000.
We have the letters. Lordship will
Will kindly come to the last page, my lord. Second last paragraph. My client proposes.
Which is the order which is impugned in FMAT 51, page number.
No, that is they have annexed at page 36.
It starts 36.
Lordship will kindly see the order.
Is only against the interim relief. So you go before the city civil court.
Yes.
And you argue out to them.
Yes.
That is the problem. This appeal. filed
In my
by the
humble
appellant is
submission, we
directed
will argue
against
the matter, but if
the order dated 30th of August 2022, passed in miscellaneous case number 3780 of 2022. We find from the said order that the notice has been issued to the appellants, directing them to show cause within 15 days from the date of the said order as to why their prayer for interim relief or injunction shall not be made absolute. The appellant / defendants were at liberty to seek for modification, alteration, or setting aside the order. Thus, the application, the case is still pending with the city civil court, and it is only an interim order which has been passed, and the final order is yet to be passed, and therefore we are of the clear view that all issues can be raised by the appellant before the learned city civil court. When we heard the appeal on 31st of January 2023, we pointed out that the question of jurisdiction, which was canvassed by the appellant in this appeal, is not a pure question of law. It's a mixed question of fact and law, and it has to be raised by the appellant before the court of first instance. In fact, we were inclined to dispose of the appeal. And however, at the request of the learned advocate for the appellant, the matter stood adjourned. Subsequently, also, the matter was heard. Thus, we are of the clear view that the appellant should agitate all issues before the city civil court, where the case is still pending, and all points can be canvassed before the learned city civil. With the above observation,
my one kind indulgence, my will kindly indicate that we have taken the point of maintainability and
that we have said.
And my lord will kindly fix some form so that it can be.
We don't know whether the court is vacant or not.
Otherwise,
the appellant is after we have dictated the order, the learned advocate for the appellant requested that a time frame may be fixed for the matter to be taken up by the learned city civil court. We grant liberty to the appellant to mention before the concerned court for an early hearing.
The 13 is the same matter. my lord.
Direction is given, my lord, but that
But it is
it
the
should
same
be disposed of as soon as possible without granting adjournment to the party. That is the
Next.
only thing.
But 13 is the same, my lord.
Common order.
13 is a different proceedings, my lord. My lord, we have taken the same point of section
42.
42, my lord. But there was a section 9 which was filed before this honorable court in its original jurisdiction, my lord. That is for which
We
all
heard
the
Mr.
points.
Ankit, what is his name?
Get
Next.
Let a copy of this application be served upon us, my lord.
my lord, I agree.
Item number 14.
My lord, I appear for the first response. My lords were pleased to, my lord, on the last occasion, direct the parties to appear before your lordship. But for that mediation thing. But I have very limited roles to play, my lord. It's between-
Anything happened?
Lord,
Mediation is concluded or?
we were supposed to, my lord, take
Oh,
instructions, my
take
lord, and
instructions.
appraise your
You
lordship.
appeared online, no, last occasion.
My lord, I.
My lord, your lordship, my lord, directed my lord, my client, my lord, to be present, my lord, on the 10th. The matter was fixed on my lord 10th. 10th, my
No,
lord.
somebody is appearing, Doctor.
But she's my client, my lord.
Rashri Roy, she is appearing. Now, your
10th, my lord, client, my lord, was physically present, my lord. The matter, my lord.
was not listed, is it?
My lord, on that day, my lord.
All right. What is your instruction on?
Yeah, my lord, in the morning, my lord, I've just, my lord, seen the, my lord, list. My lord, I could not be, my lord,
Your client is not willing for mediation.
of that matter, my lord. Kindly, my lord, keeps it on Monday, my lord. I'll instruct him to be present, my lord, on in virtual mode, my lord. My lord, right now, my lord, he has flown back to my lord, England.
No, if he is not willing, you please tell so that we can do something to the matter.
My lord, lordship, my lord, if your lordship is inclined, my lord, to take up the hearing matter, my lord, I'll not oppose.
All right, madam. That is your elder brother, no? Huh? Your brother is not willing for mediation. Namaste. Your brother is not willing for mediation. So we need to hear out the matter on merits. Probably it will take some time.
পরিষ্কার করে বল না
My lord, not willing, my lord, is not the, my lord.
Yes, you say yes or no. You are trying to beat around the bush. Then
My lord, your lordship directed my.
see,
my lord, to
they
be
are
present
both
physically.
educated, highly educated, well-placed persons.
My lord.
And there is the matter is lingering for so many years.
Well.
What is wrong in an attempt to come to a table and it's only an exploring a possibility of settlement.
My lord, your lordship, my lord, keeps it on, my lord, Monday itself.
Monday it can't keep. We will keep it subject to payment of 1 lakh cost payable by your client. The other day you said there's some connectivity issue. He could not appear, etc.
Yes,
And he was very much in Bangalore.
yes. My lord,
And he has now gone back to London, UK.
17th, my lord, his flight was, my lord, scheduled. 17th.
So now where is he now today?
London, my lord.
This attitude we don't appreciate.
It was already, my lord, pre-scheduled, my lord, his entire, my lord.
True, sir. At least he can give you instruction, no? Otherwise, report no instructions.
No, my lord, not that, my lord. My lord, I'll, my lord, persuade him, my lord, to.
What is the impugned order?
Kindly have a look at, Lord, the order number 8 at the 139. And
The
then
appeal is by the promoter. Page number?
Lord, given the entire, Lord, entire possession of the property. We are in possession of the property through our, my lord, our tenants and also, my lord, in every way. Kindly have a look at the first agreement first, my lord, on 20th of November 2016. At page 26, my lord. This is the first agreement. This is, my lord, by the original lessee. My lord will find the parties, my lord, Didendra Kumar Rai, Urmila Kumar Rai. They were the, my lord, the parents. Here, my lord, kindly have a look at page 29. Show your lordship a few, my lord, of the stipulations. My lord, kindly have a look at G onwards. Possession, my lords, kindly got it, Lord. Possession of the building shall be handed over to the developer, and lessee or owners authorize their daughter Rajashri Rai to hand over the possession of the existing building to the developer. The lessee or owners authorize Rajashri Rai to represent lessee or owners in all respect, and further authorized to represent lessee or owners in connection with any future agreement, supplementary agreement, and or addition and alterations. And then below, this is the arbitration clause. Yes, and below the amount your lordship will find. Lord, your lordship had seen this on the earlier occasion as well, and page 29.
No,
clause
what
E.
is the, what was the injunction which was granted?
Not to disturb my possession at all.
Now on,
It's not. Initially, it was granted, and kindly looks to the impugned.
no, the order impugned is vacating the interim order.
Yes, not to disturb my possession, my lord.
Now, the reason given by the court is that the document is unstamped.
Yes. Now, document if unstamped or not, my lord, is not for, my lord, in my respectful submission, not at the section 9 stage. NN Global, my lord, SMST was actually, my lord, sent to, my lord, the larger bench, and NN Global is the judgment which holds the field now, which says even at the ad interim stage, my lord.
Order number 2. But whether this issue, the section of state. When we
Mr. Chatterjee, we propose to hear out the appeal itself next Friday.
My lord, the problem that I am facing after, my lord, your lordship's order, my lord, of mediation, kindly have a look at, my lord, every day there is disturbance. We've gone, my lord, to the police. We've reported to the police has come. Then since the police was not doing anything, we went to court. The court has directed, my lord, investigation. Kindly protects my possession, my lord. In the meantime, every day, my lord,
Investigation with regard to
my tenant, every day, my lord, kindly have a look at my complaint. Have a look, complaint. The complaint, every day they would go and say, my lord, disturb that I am the owner of the property. I am the one who is here.
Proceed with the, all of you are ready with the hearing of.
For hearing, my lord, kindly takes it up, my lord, next Friday. Hearings, my lord.
State and conclude your submission, they will reply on the.
Status quo in the meantime, my lord, I can come back next week. I have no problems on that.
Mr. Chatterjee, only one.
Was protected by section 9.
Status quo, Mr. Chatterjee, one difficulty is whether
My
the
lord,
son can be bound in the arbitration.
That's why I say, my lord, prima facie sees the first one.
You are,
he claims
you are
the
going
rights
by
of the
the,
parents.
Mr. Chatterjee, you are going with the expression heirs, representatives as mentioned in the original
Not
agreement.
even that. Bear with me for a minute. That agreement, he is not claiming an independent right in the property. He is claiming a right through his parents. And
you recognize him to be
the son of the first party.
Yes, no doubt he is the son.
Yes.
Do you recognize that after the death of the father and mother, he has some right over the property? Do you recognize this?
Whether
Yes
he
or
has
no?
a right or not, that is to be adjudicated.
So, Mr. Chatterjee,
Whether he has a right.
Only one thing, if, because your case is that only the daughter is bound, because the subsequent agreement is only with the daughter. So this has to be looked into qua the property.
Yes.
So you first agreement also, the daughter was only authorized to look after to hand over possession. Whether we have to decide this, whether the son can also be bound by the
So, my
interim
lord,
order.
there is a dispute that my lord would decide. So in the interregnum, my lord, I am entitled to, my lord, one protection.
So you can make your submissions. If they are not ready, they will complete on the next Friday.
I have no problem. Kindly turns to, my lord, I'll take one after the other. looks to the first, my lord.
And only one thing, what happened to the larger bench with regard to this stamp issue?
NN Global, my lord,
Insufficiency.
I am told NN Global, my lord, has been.
NN Global, I think at the
Argument
time
was
of
on.
hearing, it was referred to a larger bench.
Argument
What
was
happened
on.
to that?
Argument was on.
But no final
nowadays-
decision has been taken on that. Larger bench is still pending.
But NN Global is holding the field. Now looks to NN Global, quoted by the learned judge. Takes up page 9, quoted. In the memorandum of appeal, my lord, internal page 9. Quoted. Internal page 9. Let's kindly go. Sorry.
23rd August 2022 order.
Yes. August?
23rd August 2020. No, that is
No,
the
no,
initial.
no.
That is the initial.
That's not the
granting injunction in our favor. Therefore,
Oh,
order
yes,
number 8.
page 3.
20.
The decisions have been quoted.
Yes, 23rd December 2022.
Yes, page 3.
Page 9. Page 9.
In,
Internal page 9.
yes.
Looks to E. This is the NN Global judgment.
Yes.
Got it, sir? Looks to it. In the case of an application under section 9 of the Arbitration Act, the situation would be different. If in an application for urgent interim release is filed under section 9 before the court, and it is brought to the attention of the court that the substantive contract is not duly stamped, the court would grant ad interim relief to safeguard the subject matter of the arbitration. However, the substantive contract would then be impounded. So at the ad interim stage, my lord, I am entitled to one, my lord. And then this is the only paragraph with respect to reasoning, my lord, in the impugned order. The next paragraph. Since the original purported documents are not before the court, which could have been impounded on account of unstamped instrument, and the same has not been duly stamped during the enjoyment of the ad interim injunction, and further virtue of the purported development agreement, although seriously challenged, creates a right in personam. Well, with greatest of respect. And
Issue
not
of
in
fraud
its-
also cannot be adjudicated by the tribunal.
Well, the issue of
That is the finding of the, now the view has been changed. That
Completely
was the
changed.
earlier view.
completely changed. Justice Nariman's judgment. Lord, the earlier judgment of Justice Chatterjee, Lord, was diluted. It wasn't changed completely, but it was diluted. It says that if there's a statutory, Lord, statutory fraud,
It
or
is so complicated that it
was
cannot be
Justice
decided by the tribunal.
that was Justice Chatterjee. But Justice Nariman says, Lord, that the law has evolved thereafter, and even a complicated question of fraud can be decided by the tribunal. Good, bad, indifferent, that's the law. And the learned judge says, my lord, that this is a right in personam. This is a right on the property.
Because of this, can we be refused to protection? The quoted Grand Global says that grant of.
Sorry, my lord, 1 minute.
No. You cannot talk, please. On karo. Mute kore din to. Mute kore.
No.
And what date injunction was initially granted?
Yes, that's the previous order.
Order number 2,
Order number 2,
dated 23rd August 2022.
23rd August, my lord.
2020.
Page
That's at page 2.
2.
There was an ex parte order or in their presence?
Expert. But a well-reasoned order.
Page 2.
Page 2, my lord.
23rd August.
23rd August. Usually, my lord, we don't, subject to correction, my lord, we don't find such a lengthy order in an ad interim stage, but it was granted.
Internal page 5.
and have a look at, it starts from 2, my lord, 23rd August, and then the ordering portion, my lord, is at internal page 5, status quo.
I don't get you. Okay, where is the extent?
My lord, in the memorandum of appeal itself, it's there, my lord. And then, my lord, your lordship will find from order numbers 3 and 4 that it was extended, my lord, in their presence.
So 23rd August 2022 to
The impugned order, my lord, 12 December. I was protected.
till 23/12.
12. And moment, my lord, this protection goes.
This
and
was
my lord-
with till 14th of September.
Yes.
Now it was, they appeared.
They appeared. In their presence, it was extended. The next orders, my lord. Order number 3, 4, 5.
They were the respondent number 2 or 1.
Dr. Rai. 2. 2 and 1. Both he appeared.
No, ex parte against 1.
One was the daughter.
Where is your miss case?
1 is the daughter. And 2, my lord, is Mr. Banerjee's claim.
2 is you.
2. Yes.
Who is really opposing? 1 is supporting you.
P.
1 is supporting you.
I'm sure she should. If not, my lord, then there'll be something.
Because she has got some additional benefit over and above the original.
Not an additional benefit.
Enhanced amount.
Yes, and amount was enhanced, my lord. My lord, I am out of pocket. Whoever, my lord, gets it, I am out of pocket. I am the one, my lord, who is in difficult.
And thereafter on 2nd of December, it was further extended.
And 23rd vacated.
Yes. On 23rd, because the original documents were not there, that's why, my lord, it's vacated. Section 9, my lord, with greatest of respect to the learned judge.
Ashwin. This miscellaneous appeal is directed against the order dated December 23, 2022, passed by the learned judge, Commercial Court at Rajarhat, District 24, Parganas North, in Miss within bracket arbitration ARB bracket closed case number 63/2022 within bracket CC. First paragraph. By the impugned order, the ad interim order number 2 dated August 23, 2022 stands vacated. First, after hearing paragraph, after hearing Mr. Chatterjee Lanet, advocate appearing for the appellant, the appeal is admitted. First, next, re-application can 1 of 2023. This is an application for praying for an injunction restraining the opposite parties and the main agents from disturbing the peaceful possession of the appellant/petitioner in respect of the property. Where is the schedule, Mr. Chatterjee?
Section 9.
Section 9, the schedule is there.
Yes, yes. It starts from 11, page 24.
In respect of the property being a three-storied building situated at plot number 1, block DB, sector 1, Salt Lake City, under police station Bidhannagar North, district 24, Pargana South. It appears from the records that the learned trial judge passed an ad interim order of injunction directing the parties to maintain status quo with regard to the nature and character of the scheduled property as mentioned in the Section 9 application till 14th of September 2022. First up, the said interim order was extended on 14th of September 2022 in the presence of the learned advocate in the presence of the respondent number 2. Here he is also the respondent number 2.
Respondent number 2.
Yes. Respondent number 2, there is respondent number 2 here.
Yes.
Respondent number 2 in this appeal. Full stop. The order was further extended by the order dated 18/11/2022, and the same was vacated by the same stood ultimately vacated by the impugned order dated December 23, 2022. First, after going through the order impugned, this court finds that the learned trial judge, while relying upon the decision of the Hon'ble Supreme Court in the case of NN Global's Marketing Private Limited versus Indo Unique Flame Limited and others, reported at 2021 4 SCC 379, observed that since the original purported documents are not before the court, which could have been impounded on account of unstamped instrument, the ad interim injunction cannot be extended. First up, the said finding is contrary to the decision of the Hon'ble Supreme Court in NN Global's Mercantile Private Limited Supra. First up, the learned judge further observes that the issue of fraud cannot be adjudicated by the arbitral tribunal, which is also against the well-settled principle laid down by the Hon'ble Supreme Court. In the case of, yes, Mr. Chatterjee, do you have that judgment? You have not got.
Look, there is one at 2021 2 SCC page 1, but I'm not sure whether they.
All right, in view of the.
I'll supply it within 1 hour. 1 hour.
The appellants have made out a prima facie case for passing an interim order in their favor. Full stop. We आगे একটা লাইন লিখুন, heard the learned advocate for the respondents. Full stop. তারপরে লিখুন, in view of the observations.
I've got it. This is 2021 4 SCC 713.
যেখানে বললাম না, ওই in view of the well settled principle of the frauded ground, reported in the case of reported in the case of Avitel Post Studios Limited and others versus HSBC PI Holdings within bracket Mauritius Limited, reported at 2021 4 SCC 713. First up, After hearing the learned advocates for the parties, this court is of the considered view that the appellants have made out a strong prima facie case for an interim order. There shall be an interim order of status quo with regard to the nature and character of the scheduled property till the disposal.
Character and possession.
Possession was not there, Mr. Chatterjee, in the original. And you have not challenged that order, you have accepted that. Till the disposal
Violence may
of
always
the
mold it.
appeal. First up. List this matter. Prepare the paper books, or this can be treated.
Everything
Parties
is here.
are appearing.
Everything is here.
Since you have filed your vakalatnamas,
Yes, yes.
both of you. Since the respondent numbers 2 are, since the respondent numbers 1 and 2 have already entered their appearance by filing vakalatnama through their learned advocates.
Caveat was filed.
The appeal is treated to be ready as regards service by way of appearances. Service of notice of appeal upon the respondents stands dispensed with. First up, the appellants are directed to file the requisite number of paper books.
It's all there, my lord. Can be treated as, my lord, because
The
everything is,
application,
everything is in.
everything you have included.
Everything.
Since it has been,
Let them
since it is not in dispute that the documents which were part of the records before the learned trial judge have been made part of this stay application, the filing of informal paper books is dispensed with. First up, list this appeal for final hearing. This is to be heard by the division bench.
as to section 9.
List this matter in the monthly list of July 2023.
My lord, kindly gives a shorter date, my lord. My lord, your lordship was of the view that, my lord, I would be making my submission, my lord, next Friday. The lordship, my lord, passes an interim order, kindly gives a shorter date.
June.
My lord, there's one difficulty, my lord. That, my lord, there's one difficulty.
June 2023. Yes.
My lord, there's already an order, my lord, of the honorable court, my lord, for my lord, by Justice Amrita Sinha, my lord, which, my lord, directs the municipality to inspect the property and, my lord, go there and, my lord, start the demolition process.
No.
There is, my lord. There is, my lord. I can
Something
satisfy
is
on that,
not
my
the
lord.
subject
There
matter,
is, my
my
lord.
lord, it's-
Kindly, my lord, that would be, my lord.
Mr. Chatterjee, if there is any violation, unauthorized construction, that the statutory authorities cannot be prevented to take
Can
it.
my learned friend show your lordship if there is a desire?
No, we cannot go into that. That is not before us.
My lord, that
But
it's not
Mr.
there, my lord,
Chatterjee,
can you
you
not
cannot say with
I shall
regard
not
to
use this order, my lord, there. I will not do that. Very well.
Ashun. It has been submitted by the learned advocate for the respondent number 2 that some unauthorized constructions have been
my lord,
made in the property.
my lord,
Yes,
two-
kindly
my lord,
record that on instruction, because I will.
on
take it-
instruction.
I will
On
take, my lord,
instruction submits that
recourse to
My
law.
lord,
some
my lord.
they have made unauthorized construction.
Yes. My lord,
The
my lord, there were, my lord. may I-
Appellant
may I-
has made
Because I
some,
will take out a 340 on.
the appellant has made unauthorized construction in the property in question.
My lord, two points
And-
were agitated.
And the learned single bench has directed, and the learned single bench in a writ petition has directed the municipal authorities to take steps with regard to such unauthorized, such alleged unauthorized construction.
We are disputing this.
We make it clear
But we are
that
disputing this, that there is no direction. There is no direction, only a direction for affidavit.
There is, my lord. There is a
Nothing
direction,
more.
my lord. I'll show.
such submission is however controverted is however disputed by Mr. Chatterjee, learned advocate for the appellant. Without entering into such dispute, this court makes it clear that the order of status quo with regard to the nature and character of the property passed by this court shall not be construed to be regularizing and or giving a stamp of approval to any unauthorized construction, to any alleged unauthorized construction. And the municipal authorities will be at liberty to take appropriate steps in that.
Well, there was 2 points agitated. One was unauthorized construction, another was change of character, nature, because residential was being treated as commercial.
Stretch it out there. We have made it only for this.
My lord, your lordship has recorded in the schedule, my lord, it's south, 24 Parganas south, it's north.
No, north only.
Yes.
Northeast. Very.
Think we have said north.
North only.
If it is south, make it north.
North. Your lordship has dictated north only.
South. My
Your
lord,
junior has now become hard of hearing, Mr. Chatterjee.
I can understand, but he was, my lord, basically, my lord is more inclined towards south, my lord, that's why, my lord.
Next.
I don't know, 15.
Yes.
But we have a petitioner, my lord. I am paying for a short passover, my lord.
It's a contempt application, my lord. We had filed our compliance report on the last occasion. Now today, my learned friend was to come up with, my lord, his views regarding the
There is
compliance.
some direction with my seniors regarding the financial part of this order, my lord. That I am paying for only short.
Then you file an affidavit. They have filed a report. If you have an exception to the report, you need to bring it on record. How we will adjudicate that?
As your lordship.
We have heard so and so and advocate so and so and learned deputy solicitor general for the respondents. The learned advocate for the petitioner seeks time to file exception to the report, compliance report filed by the respondent. How much time you want? 2 weeks? All right. Matter stands adjourned. You give a date, sir, after 2 weeks. Next.
Grateful. I don't know, 16.
My lord, this is my application, my lord.
Yes.
My lord, may I take your lordships through your last judgment dated 7th February, my lord. The operative portion is at page 31, your lordships. Paragraph 6, your lordship.
Result appeal is disposed of, directing the appellant to file an application before the authority for revocation. Application authority shall cause inspection of the premises of notice, produce documentary evidence to establish business activities, liberty to make written submission, pass appropriate order.
My lord.
Our order has been passed on 18th of April. There is a some delay because we asked for some document within 18th March, but 20th March, my lord, they submitted the documents.
What you have rejected it?
No, my lord.
My lord, may I submit, my lord? The my application for revocation of the cancellation of registration was submitted on 3rd of March, your lordship. And as per your lordship's order dated 7th, the inspection was, the order was to be passed within 18th of March, your lordship.
Correct. That the government accepts.
Yes.
Huh? You challenge this order.
Yeah.
This contempt petition has been filed.
He has
alleging willful disobedience of the order and direction. Judgment and order dated 7th February 2023, by which there was a time limit fixed for the respondent to consider the application for revocation of the cancellation of the license. There's no doubt, full stop. The learned government council submitted that order has been passed by the authority on 18th April 2023. Though the order is not within the time frame fixed by this court, yet considering the reason assigned by the respondent for not being able to strictly adhere to the time schedule, we do not wish to initiate any action for contempt as the summons, as the direction has been complied with, though not within the time stipulated. Therefore, the contempt petition is disposed of, giving liberty to the appellant to challenge the order dated 18th April 2023 before the appropriate form.
I'm grateful.
Next.
My lord, the order dated 18th April is ready by way of a supplementary affidavit. May I place it on record?
Pardon? But the order has been, my lord, supplied to them. They prepared a supplementary affidavit on it.
Next.
Item number 17.
May it please this honorable court, my lord. Lord, probably, I dare say, my lord, lordship will not take me amiss. Probably this is a matter where lordship might just be tempted to issue a rule without even calling for
Service.
service. Lordship sees what has happened. I'll just, in 3 lines, I'll put forth the matter. Lordships had directed a refund of principal amount along with interest. Thereafter, I was called upon by the authorities. I went there. They asked my bank details. I gave to them. Then they issue me a letter saying no interest is payable to you. And on the very next day, they attach my bank account. On the next, they issue me the refund, and on the very next, they take it out. I'll show you, lordship. Page 36, my lord, kindly comes to. That is your lordship's order, where my lord had been.
Now, direction is to refund 1.64.
1.64 along with interest.
Statutory interest from August 2016.
My lord, lordship kindly
What they
comes
do?
to page 36 once. Lordship's own observation, lordships kindly see. Paragraph 7, my lord. I'm at 1, 2, 3, 4, 5, 6, 7, 8, 9th line from the bottom. There is also nothing placed on the record before the tribunal or before this court to show that the demand was pending prior to the issuance of the refund order in Form 27 or subsequent to the order. The respondents are not justified in linking both the proceedings. After the issuance of Form 27, in which it has been clearly recorded that the appellant had paid excess tax, it is the duty of the department to refund the said amount, and if the amount is not refunded within time, the appellant assessee would be entitled to interest on the same, as the department seeks to recover alleged tax dues with interest. The same principle will equally apply to the department as well when they have withheld the refund, though Form 27 was issued as early as on 4th August 2016. Thereafter, my lord, in the paragraph 19, the order.
Now, what they did, what is the modus they adopted?
Lordship kindly comes to page 48. Page 48 is the order where, my lord, I appeared there and they entered the appearance. Page 49 is the letter where they say I am not eligible to get. Kindly see the letter, my lord. I am shocked and appalled to see the wordings of the letter. My lord, I will place it from the second paragraph. Page 49. Second paragraph. The expression statutory interest means interest payable under the statute. Therefore, what the honorable court has directed is that if any interest is payable in the terms of statute, it should be paid for the period of delay from August 2016, the month of audit report, till the date of making actual refund. Now, the moot question is whether any interest is payable in the present situation under any terms or provisions of the relevant statute. The relevant statute is the WB VAT Act 2003. My lord, kindly turns the page. And the only relevant provision governing the liability of commissioner to pay interest for delay in making refund is contained in section 36 thereof. While section 36(1) provides such liability to pay interest for delay in making refund arising from an order passed under appeal, suo motu revision, revision or application, revision by board, review. Section 36(2) provides for such liability where the refund arises from an assessment order passed under section 46, and that too in respect of the period stating on or after the first day of April 2014. In the present case, refund did not arise from any orders passed under such and such and such. So the provision under 36(1) is not relevant. This leaves us to explore as to whether section 36(2) is attracted or not in the instant case. A cursory look at the provision of section 36(2) will reveal that it is not attracted in the instant case because first, the excess amount did not arise from the assessment order, but instead arose from the audit report drawn under such and such. Secondly, period involved being 1314, which is prior to 1/4/2014. Therefore, neither subsection 1 nor subsection 2 of section 36, which happens to be the sole provision laying down the liability of the commissioner to pay interest, is attracted in the instant case in hand. Hence, no statutory interest is payable to you. Had it been payable, then such interest would have been paid to you in terms of the order of the Hon'ble Court for And then, my lord, in the contempt notice, I highlighted your lordship's paragraph. Lordship kindly comes to my contempt notice. It is annexed at page 61. 62, lordship kindly takes. I highlighted your lordship's paragraph. Paragraph 1, my lord kindly sees the clear mandate as evident from the directions contained in the solemn order dated such and such. I highlighted the paragraph that your lordship had stated, and thereafter I had also called upon them and beseeched them to kindly follow the solemn order. And I also said it is not for you to decide and sit on.
No, if he wanted a clarification,
they could have made
could
a
have come
sort
to
of,
court.
my lord, we had personally appeared before them and said, you can move a
Already,
clarification.
you serve, Mr. Ghosh is here, you serve. We directed refund with interest. Now he passes a judgment saying that there is no interest paying. They could have filed, you could have filed an application here saying that for such a reason it's not payable. We could have adjudicated and yes.
Lord, they filed a review.
Our
Review
reasoning was.
Cannot sit in appeal with the
So let him be here.
I have to take instruction. I take instruction and come back.
And my lord, my account has
Can't be
been
worse.
attached. They gave me that principal amount, took it back. I have given the attachment.
How they took it back?
My lord, because they have attached it. What they did, they took my details of the accounts. They said we are issuing the refund. They first attached the account on some imaginary dues. Whose
They have swiped
Form
it off
27
against.
Yes.
For some other dues.
For some other dues, whose Form 27 I have never received. I have never received Form 27. My lord, I know this is beyond perhaps the strictest purview of contempt. But
No. Before that attachment, or at least the attachment notice should contain particulars for what purpose they are attaching.
My lord, that attachment notice reflects upon a due. I have included that attachment notice. My lord, kindly see this attachment notice. It says a due of 2009-10.
Page?
My lord, page number 131. Lordship kindly comes to thank you so much. Yes, this is the notice of attachment. Lordship kindly says this is, no, this is the reply, my lord. This is the reply. This is not the notice. I stand corrected. The notice at.
Be it as it may, my lord, let him, my lord, supply me a copy of the petition, my lord. May I come back, my lord, before your lordship, my lord?
No, my lord, it is not in the CPN. But yes, that notice has been given on some imaginary dues, of which Form 27 or Form 20 it was never served upon me. And under the VAT laws, lordships know much better than me, my lord. Until and unless a notice of demand is given to me, they cannot recover anything. And my lord, I will also tell you.
So what he says is, separate garniship proceedings have been initiated under section 60 for the period 10-11, 16-17, 12-13, 14-15 and 15-16.
Lord, I have the writ against which.
No, that is a separate matter.
No, lordship just sees the notice. I'm here to just show the notice, my lord. Just lordship sees the notice. It is on 22nd of. This is given on 22nd of March, my lord. The account has been attached on 22nd of March, and on 21st of March, they have asked for this all these documentations, my lord, from me.
This is an independent proceeding.
It is. It is.
But
true,
it may
my lord.
not be a
It is,
contempt.
It is. I'm
But
not
prima facie that so far as his interpretation regarding interest is contempt.
My lord, I am on it. I am on it, and that is why I did not make it a part of this contempt application. I had challenged it by the separate writ petition, my lord.
You should have. He should have come to you with the papers and said that this observation of the court is wrong because he is not entitled for interest. You file a review or file a clarification.
But the review was filed and the review failed because what they said.
But this ground was not raised.
This was never raised because your lordships had given me interest on equity. It was I only was the person, my lord, who pointed out that under the statute there is no such provision, and lordships given me on equity. My lord, they are not talking about equity. Who is? I toned down, my lord. The question of section 36 does not.
We will give him one chance. The learned advocate is directed to serve Mr. Devashish Ghosh, learned State Council, to
Lord,
enable the
let no
council to.
coercive action be taken against me in the meanwhile. Because if now they give me the refund, they will once again siphon it off.
No, next Friday. Huh?
Lord, no coercive action.
In
in the-
what, already action has been taken, you have finished, they finished you off. Huh? So, who's directed to get instruction in the matter, list the matter next Friday.
Milord,
My
may
learned
I-
friend will supply me a copy of the
Right
matter,
now,
then I
right
will.
The learned advocate is directed to supply one set of papers to the learned.
Milord, I've
take
given,
notes.
I've given.
Yes, thank you.
Milord, may I humbly submit one thing, Milord? If lordships can just take up this matter a bit earlier.
Bit early.
Early.
No, next Friday, it can't be bit earlier than.
Very well, lordship. Very well, lordship.
Please.
Grateful.
I'm grateful to my lords.
No, we are going. If you want, we will.
Each is any audit.
Grateful.
But afternoon only, what to be disturbed? You after. Original. 2:30.
That should start another. So when should be 2:30. Yeah,
May I have your kind leave to mention two admission stage matter? It was returnable on 16th February. After that, can it be on 3rd of May? Because outstation council, Mr. Percy Pardiola is coming.
3rd May. By next Wednesday, we'll confirm.
Should I mention again? On
You can contact the SEO.
grateful, my lord.
Please call.
My lord, the item 6, my lord, led by Mr. Om Naran Rai.
Let it reach. Let it reach. No? It won't reach today, I think. Let us. Item 1.
I'm appealing, my lord. The service is complete.
Delay can be condoned, no problem.
My lord, there's a delay of 47 days.
Where are your questions?
Questions, my lord, at page
Page 3. Whether any earlier decision is there?
With the judgment of the Honorable Delhi High Court on section note 44 BB, similar provision note, because note when in the presumptive taxation scheme, not 5% or whatever percentage note of the turnover is not has to be paid as taken as income.
But in the assessee's own case, it's not covered by earlier orders.
No, there is in fact there's a decision of the settlement commission in the assessee's case against which the revenue has filed a writ petition. That writ petition is pending.
It's pending. We'll admit this matter. Yesterday, Supreme Court has passed an order. In transfer pricing, facts have to be gone into. A batch of almost 190 appeals were allowed, and the matters have been remanded back to the High Court.
But here, of course, it's not transfer pricing. But here the question is whether the service tax component should be included in not computing the for presumptive taxation, because there's no element of tax in it. Sorry, profit in it, and it is not on account of the service rendered. It is to be collected and paid to the government. So that is how the.
Maybe you can admit it because the writ is pending. We have heard Mr. Amit Sharma.
I'm led by Mr. Kundali.
Mr. Kundali. So and so, and Mr. J.P. Gaitan, Richard Zinjua. There's a delay of 47 days in filing the appeal. You have perused the affidavit filed in support of the petition. Find sufficient cause has been shown for not preferring the appeal within the period of limitation. Hence, application allowed, delay condoned. Appeal is admitted on the following substantial questions of law. Page number 3 and 4, 1 to 5. 1 to
proceedings, you preempt it. And that is not the exact ground on which the first interim order was passed. Your lordship has seen. When the petition is pending, please do not transfer, because that will render this infructuous. That was the basis for the order. And my lord, that is the basis on which, my lord, the court always steps in and passes a, my lord, mandatory order at the interlocutory stage, because once notice is given of a proceeding, you cannot render it infructuous. Now, this is what he's telling your lordship. Lord, I hate to say it, but what he's showing is a thumb to the court. You come to court, I will render your petition infructuous. Lord, never heard of this from a public body. I can understand, Lord, two commercial bodies, Lord, wrangling over commerce doing this. But a government body, Lord, doing this, Lord, not once but twice. I've never heard of it. Lord, this itself, Lord, on its own, should be a ground, Lord, to immediately stay this and put the clock back. Lord, my learned friend,
Yes.
Lord, my learned friend took, Lord, I would say chose to take a technical stand and a technical stand only. He did not face it on merits. Now, my lord, when he sees it's in, Lord, danger, now he says he wants to make submissions. But, my lord, having once taken the risk of running purely a technical argument, and then, Lord, once it is shown that this technical argument is wrong, Lord, he is supposed to know what his, Lord, RBI permits him. If he, Lord, gives the impression that no, I am permitted to transfer, and the law does not, Lord, will your lordship, Lord, then permit him to stand up and make submissions again now to the contrary? Lord, please don't permit them to make any further submissions. Lord, we have made our submissions. Please give me a chance to survive. And Lord, this kind of conduct, Lord, should not be condoned by court.
Lord, conduct
Lord,
has to be only on one
say,
side.
Lord, this is a case, Lord, this is a case where, Lord, punitive costs ought to be imposed, Lord.
Kindly permit me,
Lord, and no further, Lord,
because, my lord, this is beginning to sound like Alice in Wonderland. It becomes curiouser and curiouser. Now, my lord, I'll tell your lordship why. Conduct, my lord, is being talked about firstly of a person who owes 441 crores. Admitted, there is no, my lord, denial of the debt. There is no denial of the default. So, my lord, kindly, my lord, proceed by proceeding on the premise that of, my lord, the admitted fact. The admitted fact, my lord, is 441 crores of debt. Admitted fact is 441 crores of default. Admitted case, my lord, is that
please
only
permit me, my lord, one line of interruption. If he's going to go into facts all over again,
I'm
your
not
lordship
going
will
into facts.
permit me, my lord, 5 minutes. He's doing that. He's doing just that.
Let him have 5 minutes, 5
law-
hours, my lord.
Law, I understand. Lord, law, I've shown
No,
him circular. Let him, Lord, deal with
No, not that way, sir. You said 238 crores was offered. They didn't accept it. Now sold it for 250. Therefore, he says that all is not well. That as on date, it is 441 crores. That's it.
My lord, I'll just indicate, my lord, let me deal with this point of, my lord, 238 and 250 crores. My lord, kindly have, my lord, two judgments of the Supreme Court. One is in the Bijnor matter, and the second, my lord, is in the Ativir matter. My lord, Arvindra matter, I'm sorry. First Bijnor, my lord, Bijnor, my lord, is the authority on the point. I'm handing up the judgment to your lordship. That, my lord, settlement is something between the parties. My lord, if I find that, my lord, somebody has led me down the garden path 400 crores, or he's coming and saying 200 crores, 238 crores. My lord, kindly see the vehemence with which he argues. I gave him 238 crores. Why did he not take it? As if, my lord, he has a vested right and interest, like he was talking about my God-given right, as if he also has a God-given right that if he, my lord, condescends to make an offer, the bank must grab it. And if it doesn't, then for all times to come, the bank must ensure that it goes at a higher price. Where does he get that from, my lord? I do not know, because that is not the law. Kindly see, my lord, the law laid down by the Supreme Court in Bijnor, followed in Arvindra. My lord, Bijnor is a decision which, my lord, says that, my lord, court cannot impose settlement. Settlement happens between the parties, well and good.
I concede.
It happens.
I concede.
It doesn't happen between the parties, well and good.
I did not
So
say
when my learned friend, my lord, in that case, my lord, he says I have been saying points of prejudice.
What is his point? His point is I gave 238 crores. Why did you not take it? And thereafter, why did I go and assign it to somebody else? So, my lord, the first point is, my lord, Bijnor, if your lordship will kindly take. My lord, paragraph
Concede the
paragraph
point.
24.
Concede this.
Just 1 minute, my lord. Just, my lord, kindly take it from paragraph 22 onwards. I'm sorry, my lord, we've taken the liberty of highlighting these portions. Having heard learned counsel for the respective parties, having heard learned counsel for the respective parties at length, the following questions are posed for consideration. Whether the benefit under an OTA scheme can be paid for as a matter of right. Whether the High Court in exercise of powers under Article 226 of the Constitution can issue a writ of mandamus directing the bank to positively consider grant of benefit of OTA scheme. So, my lord, whether the court can intervene to bring about settlement. Thereafter, my lord, kindly have page 20, paragraph 24 at page 6. Therefore, as per the guidelines issued, the grant of benefit under an OTS cannot be paid for as a matter of right. Same is subject to fulfillment of eligibility. Then, my lord, below that, as per the guidelines, the bank is required to constitute settlement advisory committee for the purpose of examining, and thereafter the said committee takes a decision after considering whether a defaulter is entitled to the benefits of the OTA scheme or not. While making the recommendations, the settlement advisory committee has to consider whether efforts have been made to recover the loan amount, and the possibility of recovery has been minimized. So, my lord, even if he fulfills the eligibility criteria, I can hold that you're a dishonest, delinquent borrower, and I will not give you the OTA scheme.
Para 20,
I am entitled in law.
para 29.
Yes, madam. Lordship is reading faster than I can read it, Lordship.
And there is another decision, para 29.
Yes, madam. Now, my lord,
Cannot to compel or direct the financial to enter into one time on the terms proposed by. Then if every defaulting is capable of paying his dues, agreement entered to like to one-time settlement.
I'm grateful. Madam. So, my
And
lord,
there is another decision,
my lord, I'll just indicate to your
South
lordship.
Indian Bank, which was delivered last week.
My lord, I'll look
We
into
have
it, but my
referred
lord,
to
just
that.
permit me to give your lordship one small, my lord, trivia. My lord, Bijnor was deferred, although it's a Supreme Court decision, deferred by DB of Chandigarh. They said that while a court cannot impose a settlement between the parties, once there is a settlement, court can extend time. Then, my lord, came Arvindra, my lord, which was carried from the Chandigarh judgment, and had nothing doing. You can do nothing in the matter of settlement between the parties. Court has nothing to do.
This principle has been reiterated in South Indian Bank.
I'll pull that out.
3 days back. So we 17th of this month. We followed it yesterday in one matter, where the court, of course, has extracted several decisions and said, like, don't issue a mandamus to consider an OTS. You should not entertain them. We will continue because there is another division bench.
But that's the reason we withdrew the first date. That was on the basis that please, there are no reasons for rejecting the
Because
OTA.
that was a prayer to consider.
Correct.
Correct. So, my lord,
Correct. But
238
I
crores,
have no-
250 crores. My lord, you cannot compel me to accept.
I am not. I did not ask him to, Lord.
And if I've accepted somebody else's bid, I've done no wrong. You're a delinquent borrower.
All right. We have heard Mr. Bachawat and Mr. Joy Shagal and its senior advocates for continuation of submissions of for hearing the submissions of the senior advocates for the respondent. When do you have it?
Tuesday, Monday, I'm in difficulty. Monday, I'm in difficulty any day.
Tuesday, last day, Monday or Wednesday?
Wednesday, actually.
Monday.
Other than Monday, my lord, subject to convenience.
Wednesday.
Wednesday. Great.
Wednesday under the same caption. Wednesday it will be in the forenoon. 10:30.
Very well, madam. We'll come in the morning.
We are in a hurry. We can't do it.
First off.
But the urgency is all us. So, whatever day your lordships can accommodate.
Monday they say they are Wednesday will be
Thursday বলবো কি?
26th.
এইগুলো নেয় খালি Monday.
You put it same like today's position. So probably it will be item number 6. It will be item 6 on Wednesday.